state is providing you counsel. And you don't get to pick and choose who they provide. But I will tell you, and I don't want these ladies to hear this because their heads will get big. I've watched them. You might have a communication problem and they need to work on that. These are competent lawyers, okay? Now, you know that he's having a problem with you right now, so
Yes.
you're gonna put a little extra attention with him and go down through the thing, okay?
Yes, Your Honor, that is our intention. Your Honor, there was one further thing. The Commonwealth reached out to us yesterday afternoon with a new offer for Mr. Southworth. The jail in Barron County has instituted attorney hours. We're only allowed
Okay, well,
in for
you can
certain
go,
periods
you
of
can meet
time.
with him here.
Your Honor, we have talked to him about the offer, but we do feel that given the nature of the offer, it is a substantial amount of time, that there may be some additional time required to have a conversation with him about that.
Well, you can meet with him here.
We were going to ask, Your Honor, if the court would be willing to put him on for the 8th in Clinton County, just to allow us to formally enter a plea if we are going to do so. It is our
Well,
intention.
there's no reason for me to, if you get an agreement, I'll docket it then. There's no reason to docket him for the 8th or do transportation orders until we do that. Do you need some time to talk to him today?
Yes, Your Honor, we can talk to him further today.
Okay, what we need to do is provide a space somewhere. How many prisoners do you have back there?
4, 5.
Well, we have one female prisoner and one male, it looks like. Will you go back there and check and see how many are back there?
There's no way to go. Have it brought there.
Do that. You can write a letter and send a copy as far as the.
There's 3, Your Honor.
Yeah, okay. Is there a room open back there somewhere?
One of the holding cells has that glass where they can sit in
Yeah,
there and speak to them
let's
through
do
the
that.
glass.
Yeah. Go, you show them where to go back to that holding cell here and they'll talk to you. Okay.
Thank you, Your Honor. We did have 3 witnesses that were originally subpoenaed for the bond hearing. We would ask if they could be
Who were
released.
they?
It was Lucas Gerald's.
Well, I thought Mr. Gerald was just visiting, Charlie.
Cause he likes this good.
He wanted, I thought he was wanting to come somewhere where he wasn't related to everybody. Okay, Mr. Gerald, thank you for coming.
Yes, sir.
Who else, Chad?
It was Mr. and Mrs. Hedger.
Are they here?
They are here, Your Honor.
Okay, they may be released too. And they'll have to be served again if they're that, but other than that, we got be on your way rejoicing, okay?
Thank you, Your Honor.
Yeah.
Thank you.
Bring out Charles Dyer. Charles Dyer. Commonwealth versus Charles Dyer. 51, 24 CR 0018. Good morning. Are you Charles Dyer?
Yes, sir.
Okay, born in 1973.
Yes, sir.
Last 4 digits of your social security number, 5164.
Yes, sir.
It says on here you're represented by David Cross, is that right?
Yes.
Running late. Oh.
I mean, every couple mates, so
Okay, well, we'll put him back there and call him back out. Jennifer Robbins. For arraignment. Commonwealth of Kentucky versus Jennifer Lynn Robinson, 24 CR 0041. Good morning. Are you Jennifer Lynn Robinson?
Yes, sir.
Were you born in 1986. Last four digits, social security number 0286. We're here today for the purpose of arraignment. Do you have an attorney? Let's go through this. Okay, has she filled out an affidavit?
I can run back myself. Here, fill out another form.
Well, I'm gonna ask the Office of Public Advocacy to stand in for the purpose of arraignment.
Yes, Your Honor.
You have the right to remain silent, okay? You understand, you have the right to remain silent. If you have any questions, step away and ask. The grand jury of Cumberland County has returned an indictment charging you with burglary in the first degree, possession of a handgun by a convicted felon, and being a persistent felony offender. Do you understand those charges? Do you understand those charges, man? You understand the charges? I'm not asking you whether you did or not. You understand the charges?
Yeah.
Okay.
Ma'am, you have to speak up. It's on the street.
Okay. I'm signing a reciprocal discovery order. Commonwealth give your attorney all the information they have to help you prepare your defense. Now, will you take her and have her sign one of these? You raise your right hand, please. You swear the testimony about to give us the truth, whole truth, and nothing but the truth. Okay, do you have any property? You own anything? Okay, do you have a job?
Oh, no, I'm on disability.
Says she's
Speak
on.
up.
I'm on disability.
On disability, okay. And how much disability you draw?
964.
Do you have any other income at all? Okay, I'm gonna go ahead and say that she's eligible, but I want her to fill out one of those things anyway.
It's
In order.
not.
Just move over here in one of these chairs here, and this lady will fill the form out, and I'll point out, so you have a lawyer. And where are you, are you in Adair County Jail? Is that where you are? Okay, when will you up there to see her? You wanna?
And
See,
Judge,
that's the
Judge,
problem.
I don't believe she's in, she says she's in Adair, she's in Warren, I believe.
Well, it'd probably be good if you had an opportunity to talk to her today, and what I might do is try to call some of these other cases so you can talk to her for a minute if you want to.
Judge, that's fine. I don't know if she was in a secure, if you want to have her do the affidavit first,
I'll go ahead and sign the order based upon her testimony.
Certainly,
Okay, will you
Judge.
take her back there and let her go through and where you talk to her through the glass. back there.
Judge, do you want to finish? I think we got started on the arraignment. Did you want to finish arraigning her, given?
We will now that we know she's gonna be a.
Yes, Your Honor.
Okay.
So I'll enter a plea of not guilty, waive
Reserve all
formal
pretrial
arraignment.
motion.
Yes, Judge.
Okay.
Judge, before we set a negotiation day, if I could, let's come back and may have a chance to speak with
Yeah,
her.
what is your negotiation day next month?
July 31st at 1 p.m. Here in Burks.
Let's just go ahead and set that. If you have anything else to bring up, you can bring it back out, okay?
Yes, Your Honor.
July 31st for the negotiation day. And.
What about my bond?
Hold
My
on, ma'am.
bonds?
Wait a second. And then August 29th.
And Judge, I'd add,
Is that correct? August 29th?
Yes, Your Honor.
That negotiation day is is that because of the prosecutors conference? Is that early?
Prosecutors conference, our schedule
Okay,
and Clinton County,
okay.
because we're doing them both the same day.
What is her bond?
This Robert, her bond is set on this case at 50,000 surety. And Your Honor, she also has had, small charges, she's got a hold in Simpson County that's 10,000 cash. She's coming back as a high 10 to reoffend and a moderate 5 for FTAs.
and Judge, if I may, I think the issue with the score on the FTA, there's an outstanding warrant, I believe, out of Simpson County, and she was in Warren County for her Simpson court date, so I think that is escalating the
Well,
score.
She's also charged with,
Here, you need
she's
to let me
also
talk,
charged with
please.
possession of a gun by convicted felon in first degree burglary. So you need to, your attorney will negotiate with the Commonwealth about your bond. If not, you can schedule a bond hearing.
Yes, Judge.
Thank you very
I'll
much.
be in about 10 seconds.
You want to go on back there and I'll call some of the other cases, okay? Bring Charles Dyer back out. Bring Charles Dyer back out. Charles.
Morning, y'all.
Hello.
I hope y'all got my message that we would be a little late. No,
Stockton.
we called our clerk's office about 8:30 or so. Sorry for being the hearing.
Commonwealth of Kentucky versus Charles Dyer, 24 CR 0018. Mr. Dyer, you previously been, acknowledged that you were born in 1973.
Yes.
Last four digits, social security number 5164. We're here on the pretrial conference. What's the Commonwealth have to
Have a
say?
felony, please.
Mr. Dyer, a motion has been tendered saying you wish to enter guilty plea today. Is that correct? You have to speak up because it's a voice activated microphone.
Yes, sir.
Are you currently under the influence of drugs or alcohol?
No, sir.
Is this plea freely and voluntarily given?
Yes,
Is
sir.
it freely and voluntarily given?
Yes, sir.
Are you the same person that we just identified in 24 CRs, 24 CR 0018?
Yes, sir.
Is your judgment impaired today in any way?
No, sir.
Okay. Have you discussed this matter with your attorney and are you satisfied with his advice?
Well, I'd like to speak to him for just a minute. Okay, please.
Step away from the podium there.
Okay.
Just stop right there, Mr. Cross. He can talk to you.
Yeah.
We're ready to shake, Your Honor. Boy, you got to send that some time to do it. That goes to 30 days and figure it out. Yes, sir. I know very helpful. Yeah, I've got the account, social security, I voice number. So.
Well, he needs. Warren can needs to do that for argumentations. And I say, I'm back over. Send her back over there. Where's his face? Let's see, standing behind the corner. Just the thing about it is, we gotta take her back over there. They've got to accept it, keep it coming, because we've got a whole. We've got a whole. So she still, if they average at midnight tonight. Unless they let, then even if they let her. She doesn't. Yeah, last night. Last night, I thought she said that's. Well. I just, we need to order. Lodge there.
It's showed out.
You'd be lodged there in Barron County, right? Where you gonna take her? Yeah. You're gonna take her at Barron. Get us, get one of those orders. These have orders. Yeah. Right. Okay, have you reviewed the evidence Commonwealth has against you and you believe you're fully informed about your case?
Yes, sir.
You understand that you do not have to enter a guilty plea today. You have certain rights under Kentucky and United States Constitution. Before I can accept the plea, I need to know that you understand those rights. You have a right not to testify against yourself. No one can make you say anything, a right to speak, trial by jury, right to be represented by counsel at your jury trial, the right to confront and cross-examine all witnesses called to testify against you, the right to produce evidence, the right to call witnesses in your favor, right to appeal this matter to higher court if you lose, right to require the Commonwealth to prove beyond a reasonable doubt that you're guilty of the charge against you. You understand that by entering a plea of guilty, you give up those rights. You understand that?
Yes, sir.
Now, I may consider the Commonwealth's recommendation, but I may apply any range of sentence provided below. I don't have to accept the recommendation prior to accepting any recommendation. I will wait the pre-sentence investigation report for probation and parole. In the event that I decide to give you a more harsh punishment than you agree to, you have the right to withdraw your plea. Go to trial. You understand that?
Yes, sir.
Mr. Stockton, what is the Commonwealth's recommendation?
Your Honor, Mr. Dyer would plead guilty to wanton endangerment, first degree, receive a sentence of 2 years. He'd, excuse me, he'd also plead guilty to possession of controlled substance, first degree, receive a sentence of 2 years. He'll also plead guilty to possession of a firearm by convicted felon. The defendant shall receive a sentence of 2 years to serve. All those sentences shall run concurrently for a total of 2 years to serve. You'll get credit for time served, pay court costs discretion of court. The Commonwealth opposes probation or shock probation.
Is that what you agreed to, sir?
Yes, sir.
Now, are you pleading guilty because you did commit the acts that are charged in the indictment as amended?
Yes, yes, sir.
Are you doing so of your own free will?
Yes, sir.
Knowing your constitutional rights, as they've explained to you, it's still your desire to give up those rights, enter a guilty plea and allow the court to fix your punishment. Do you understand that by entering this plea, any future conviction that you might have could be enhanced under persistent felony offender law? Do you understand that?
Yes, sir.
Is that your signature? You have the plea agreement there?
Don't have it with me, Your Honor.
Where is the plea agreement?
Mr. Stockton said he had a copy. I don't even have a copy. No, I don't have a signed copy. You've got the copy?
Well, I was
changing my.
I was in the court file. I was looking this morning and
Oh, I got a copy of the offer. I don't have the motion. I'm looking for you. Okay. You can have this copy, but
what's
motion in your
that will be counts. I'm not bewildered on where it is. Sign right there. I apologize, Your Honor. We'll correct it.
Yeah, I'll accept the agreement. Order pre-sentence investigation report to be done by probation and parole. The sentencing will be on August the 29th.
Thank you.
Thanks, sir.
Kenny Allen. There is an active warrant on Kenny Allen, Mr. Stockton.
Yeah, we'll put him in CISA.
Ronnie Bays.
Mr. Hunley, you ready to report on that? Mr. Bailey's will stand for you. We're ready to set it for trial, then? Good.
Como versus Bronny Bays, 22 CR 0026. You are Bronny Bays. You were born in 1984. Last four digits, social security number 5442.
Yes, sir.
Your date for pre-trial conference. You ready to sit for a trial?
I suppose we'll have to be, Your Honor. We don't have any. Well, I was hoping it would,
Are you ready to do it? Sit for the trial?
yeah, it needs to be out. I was considering our docket in Monroe for the next.
And Judge, I would agree with Mr. Hunley. I have a 2-day, pretty extensive trial in Clinton County, the middle part of September. I have a 3-day federal trial at the end of September. And I will be out the first few weeks of October.
I had October in mind, you're right.
What about August 19th and 20th? Get your calendar with you. August 19th and 20th.
Judge, we've got more to say grace over. I can't do that fast then. That'd be wrong for the court.
What about for the first week in October? You're not available
Judge, I will
anytime?
not, no, Your Honor. I will not be in the country.
How about the 15th and 16th of October? You gonna be available on the 15th or 16th?
No, Judge.
How about the 14th?
Judge, I won't be back in until, or available until the 17th.
How about October the 22nd?
Judge, that works for the defense.
That's fine, Your Honor.
I'll be looking at that.
Can't do that.
Judge, all the fault of the Commonwealth, I know
We can't do that. Okay,
two.
cannot do that today.
2 days. Yeah.
That's, so
That's the judicial college. Y'all can't do the August 19th and 20th.
I don't think so, Judge.
I've got some doctor to be available next week.
What about November 12th and 13th?
does that work for the defense?
Assuming I'm still here, Your Honor, all that works fine.
Well, that's true for all of us. Did I say the 12th and 13th, or was it 11th and 12th?
I wrote down 12 and 13.
Eleven's a holiday.
Yeah.
11th.
Sorry.
Veterans Day.
Okay,
Thank you, Judge.
yeah.
Thank you, guys.
Commonwealth versus Ramona Bird. Ramona Bird. Commonwealth versus Ramona Bird, 24 CR 0046. Are you Ramona Bird?
Yes,
You born in 1969.
yes,
Last four digits social security number 9222.
yes.
You're here for the purpose of arraignment. You're with Mr. Poindexter. You have the right to remain silent. If you have any questions, step forward and hold your hands. The grand jury of Cumberland County is returning an indictment charging you possession of controlled substance in the first degree methamphetamine, trafficking in alleged drug, possession of drug paraphernalia, and possession of marijuana. Do you understand those charges? You understand what those charges are, ma'am? Ma'am, do you understand? I'm not asking you if you did it or
Yes.
not. You just understand what the charges. I'm signing a reciprocal discovery order. The Commonwealth has handed you certain information. Your attorney there is under continuing obligation to do so. Keep you informed about your case. You're to be here at 9, is it 9 a.m.?
1 p.m., Your Honor.
What's going on at the Commonwealth's, I can hardly see you. Yeah. Okay, 9 a.m. on July 31st, you'll be here,
Be 1 o'clock.
1 o'clock?
Yes, on July 31st. Yes, sir.
July 31st at 1 p.m. And then back here in court again on August 29th. And ma'am, both of those are conditions of your bond. Okay? Sarah Black. Sarah Black. Commonwealth versus Sarah Black. Are you Sarah Black?
Yes, sir.
Were you born in 1977?
Yes,
Last four digits, social security number 0901.
yes.
You're here on 24 CR 0043 for arraignment. You represent the Office of Public Advocacy.
That's correct, Judge.
You have the right to remain silent. Grand jury of Cumberland County has charged you with possession of controlled substance first degree methamphetamine. Driving on suspended license. Failure to maintain insurance. Expired plates, no registration. You acknowledge the identity of your client counsel, receive the indictment, wait formal reading or in the plea not guilty, reserving all pre-trial motions.
Yes, Your Honor.
I'm signing a reciprocal discovery order, ma'am, that requires the Commonwealth to provide information you have your case. Some of it's already been given there, your counsel. You should be back here for a negotiation day at 1 p.m. on July 31st, and your next court date is August 29th at 9 a.m. Okay.
Thank you, Judge.
David Collins. Commonwealth versus David Collins, 24 CR 0039. Are you David Collins? Yeah. Born in 1986. Last 4 digits, social security number 6441. Yep. You're David, for the purpose of arraignment, you have a right to remain silent. You're represented by counsel. If you don't understand something, you have to step away from the podium and ask Mr. Torrance. The grand jury of Cumberland County has returned indictment charging of possession of controlled substance in the first degree methamphetamine. Possession of controlled substance. Drug unspecified. Obstruction view of the windshield. Failure to eliminate your registration program. Failure to use seatbelt. You understand those charges? Mr. Poindexter, you acknowledge the event here, client received out and wait formal reading and arraignment and pleading not guilty, reserving all pretrial motions.
I do, Your Honor.
Sign a reciprocal discovery order, sir. The Commonwealth to provide information to you to help you prepare for your defense. She'll next be here on July 31st at 1 p.m. for negotiation. And your next court date is August 29th at 9 a.m. Both of those are conditions of your bond. You understand that? Yes. Great. Jason Hooks. Commonwealth versus Jason Hooks, 24 CR 0047. Are you Jason Hooks?
Yes, sir.
Morning. Were you born in 1973?
Yes, sir.
That's 4 digits, social security number 7669. Do you have an attorney?
No, I can't afford one.
Have you filled out an affidavit?
No, sir.
Take this gentleman over in that jury box over there, and fill an affidavit. We have an Adair County case here at Village. For sentencing. Roy Ingram. Mr. Wright, are you on there?
Yes, sir. Good morning, Judge.
Good morning. Commonwealth Kentucky versus Roy Ingram, 20 CR 00175. Are you Roy Ingram?
Yes, sir.
You born in 1979? Yes, sir. Last 4 digits, social security number 4283. You're here today for sentencing. Have you had an opportunity to look at the pre-sentence investigation report done by probation parole?
Yes, sir.
Is it substantially correct?
Yes, sir.
Counselor, is there any reason why this gentleman should not be sentenced today?
No, Your Honor.
So on count one, he should be sentenced to 10 years on possession of handgun by a convicted felon. Count 3, 10 years on criminal possession of a forged instrument in the first degree. Count 5 years on tampering with physical evidence. Count number 7, 12 months in jail for fleeing or evading in police the second degree, 12 months in jail for resisting arrest. Count 9, 3 years in possession of controlled substance, first degree methamphetamine. Count 11, 12 months in jail for possessing controlled substance in third degree. And count 12, 30 days in jail on possession of marijuana. Of course, those misdemeanor charges will run with the felony charges. And all the other charges shall run concurrently for 10 years. There's a recommendation, probation of 5 years.
Your Honor, on Mr. Ingram's behalf, there was a co-defendant in this case who was driving the vehicle.
Well, I'll see that in the pre-sentence investigation. And so will order a pre-sentence investigation report to be done by probation and parole. Y'all are keying that mic over there.
It is on for sentencing today, Your Honor.
Yeah, well, I'm looking at. Mr. Wright, tell me about this gun charge here.
Sure, Judge. This gun was found in a car that Mr. Ingram was a passenger in. It was found, he indicated he was the owner. I think if you recall, there was a suppression hearing and later it was determined that he was not the owner of the car. And I'm trying to see exactly where the gun, it was under the center console. And the defendant said it was his father's gun. The car did belong to the father, and so there was some question about the search, and I know the court had taken that under consideration and under advisement. I'll tell the court, Mr. Ingram was probated a few months ago over in Taylor County, and I have been in contact with probation and parole. They've told me they've had no problems with him over there. We had previously offered a lower sentence with an opposition to probation, but this was a higher number, giving him an opportunity to remain on probation. He's been supervised by pretrial for the better part of about 3.5, 4 years now, and seems to have had very few, if any, problems, certainly none recently, with that type of supervision. And that's the basis for the recommendation of probation in the case.
Is your client doing the substance abuse with a recommendation?
Your Honor, he is supervised out of Taylor County. Have they started? What, oh, but out of Taylor County, do they have you go? Social? They have not, but if the court wants him to do that, he is more than
Yeah,
happy
it
to.
says Commonwealth recommends probation defendant shall comply with any all substance abuse treatments recommendation by the Division of Probation and Parole. So,
Yes, so if they reassess him, or I didn't know if they had assessed him prior.
okay, he's on probation from another court.
Correct.
What will you do? I'm talking to probation and parole. Will you do another pre-sentence investigation report update, or what will you do usually?
Or, we already did a pre-sentence investigation for this case.
Yeah, but I know what you did one, but when you do it, you do it. I was asking a question. The question was, do you do one? And it is, yes, you've done one.
Yeah.
Now, what do you find about the substance abuse? Do you recommend it, or a clinician need to be with him subsequently? Is that what will happen?
Yeah, if it's in the court order, Your Honor, we'll have him assessed by the social service commission, and she makes a recommendation, we'll follow through with reports tonight.
Well, I'll go ahead and agree with the silence order, but I want to make sure that he looks at the substance abuse clinician situation. I'll tell you, Mr. I don't like weapons with people that have drugs on them. But Mr. Wright is usually pretty tough. He stood up, said, made this recommendation, said it was okay, so we're gonna do that. But I will tell you, you don't need to be around any handguns, any drugs or anything. It's like, everybody deserves a second chance. You've got like 2.5 here, so I hope things turn around for you. I really do. You need to meet with him at all.
Now he needs to report to the probation officer that he's already signed to.
Okay, good luck to you, man.
Thank you, Judge. And I'd sent a proposed forfeiture order to Megan earlier. If it needs to be changed, just let me know.
Okay, thank you.
Thank you.
Thank you, sir.
Let's get Mr. Hooks back up here. Caldwell versus Jason Hooks. 340 CR 0047 for arraignment. I looked at the affidavit that appears that you are. Else we'll get a public advocate. Oh. You have a right to remain silent. The grand jury of Cumberland County has returned to the indictment charging you with possession of a handgun by a convicted felon. Possession of controlled substance to first degree. Firearm enhanced to class C felony. Operating under the influence. Possession of drug paraphernalia. Possession of marijuana. Failure to maintain insurance. Reckless driving. Expired plates. Speed. Counselor, do you acknowledge the identity of your client preceded that way formal reading and arraignment? You know, plea of not guilty, reserving all pretrial motions.
Yes, Your Honor.
What is Mr. What's his bond here?
Posted, Your Honor.
Okay. And where do you live, sir?
Oh, God.
Give me one of those waiver of extradition forms. Yeah, I want your clients to sign a waiver of extradition.
Yes, Your Honor.
You know, that means that you'll come back to Kentucky without us having to send the dog for function. You know, to them.
Madam President.
I'm signing a reciprocal discovery order to
Judge, I'll acknowledge Mr. Hooks did execute the waiver of extradition in open court.
Okay. Thank you very much. You need to be back here on July the 31st at 1 p.m. for negotiation. And August the 29th for your next court appearance.
And Judge, if I may, I'm not going to ask for the convenience for the pretrial conference date, especially if we have a resolution. But just given the distance, if I may, if Mr. Hooks could participate, via Zoom or kind of start those negotiations, given it's next week and he's in North Carolina. I just want to make sure with the court before I.
Well, I can lodge him here in Kentucky.
Well, Judge, I'll
just stay here.
guess you're coming back next week, bro.
Well,
That's fine, Judge.
I tell you about driving. In order to be here at 9 o'clock this morning, I left White Sulphur Springs, West Virginia, at 9:30 last night. So you can make it here, pretty straight road. Get over there. Okay. Thank you very much.
Yes, Judge.
Yeah. James Jackson. Commonwealth of Kentucky versus James Jackson. 24 CR 0030. James Jackson. You born in 2001.
Yes, Your Honor.
Last four digits of social security number 4257.
Yes, Your Honor.
We're here for a pretrial conference. You're represented by Mr. Cross. What do you have to come?
Diversion plea.
Okay. Sir, a motion's been tendered that says you wish to enter guilty plea today. Is that correct?
Yes, Your Honor.
Are you currently under the influence of drugs or alcohol?
No, Your Honor.
Since plead freely and voluntarily given.
Yes, Your Honor.
Are you the same person named in the indictment?
Yes, Your Honor.
Is your judgment impaired?
No, Your Honor.
Have you discussed this matter with your attorney and are you satisfied with his advice?
Yes, Your Honor.
Have you viewed the evidence the Commonwealth has against you? You believe you're fully informed about your case?
Yes, Your Honor.
You understand that you do not have to enter a guilty plea. You have certain rights under the Kentucky United States Constitution. Before I can accept the plea, I need to know that you understand those rights. You have the right not to testify against yourself. No one can make you say anything. Right to be trial by jury. The right to be represented by counsel at your jury trial. The right to confront and cross-examine all witnesses called to testify against you. The right to produce evidence. The right to call witnesses in your favor. The right to appeal this matter to a higher court if you lose. And the right to apply the Commonwealth prove beyond a reasonable doubt that you're guilty of charge. Don't you understand that by any guilty plea today, you give up all those rights? Now, I may consider the Commonwealth's recommendation, but I may apply a range of sentence provided by law. I don't have to accept it in the event that I do not accept the Commonwealth's recommendation. You have the right to withdraw your plea of guilty, proceed to trial. Now, I'm going to ask you a few questions about your qualification for pretrial diversion. Have you previously been diverted in the last 5 years?
No, Your Honor.
Do you have any felonies in the last 10 years?
No, Your Honor.
Are you currently on probation?
No, Your Honor.
Pretrial diversion. You understand if you complete the pretrial diversion, charges will be dismissed pretrial diversion, you can have them expunged from your record. You understand that?
Yes, Your
You
Honor.
understand that if you don't successfully complete it, you're brought back in front of me, I avoid your pretrial diversion, I'll schedule a pre-sentence investigation report. If you sentence, you get a convicted felon, that could be used against you in the future. You understand that? Ms. Gordon Anderson, what is the Commonwealth's recommendation?
Upon a plea of guilty to possession of a controlled substance first degree, the defendant shall receive a sentence of 3 years, pretrial diverted for 5 years. Diversion is to be supervised. Upon a plea of guilty to operating a motor vehicle with alcohol concentration of or above 0.08 or while under the influence of alcohol or other substance first offense, the defendant shall pay a fine of $200. The defendant shall be assessed and follow any recommendations of the social service clinician. The defendant shall pay all fines and court costs at the discretion of the court. The defendant agrees to have any and all drug paraphernalia and contraband disposed of in accordance with the laws of the Commonwealth of Kentucky.
Is that what you agreed to?
Yes, Your Honor.
Are you pleading guilty because you did commit the acts charged in the indictment?
Yes, Your Honor.
Are you doing so of your own free will?
Yes, Your Honor.
On your constitutional rights, is it, I've explained to you, is it still your desire to proceed with this plea to allow the court to fix your punishment?
Yes.
Is that your signature on the docket?
Yes, Your Honor.
I'll accept the agreement, sign the diversion order.
Your Honor, we also have the DUI guilty plea form, which he is signing as we speak.
Let me get to this. What are the total court costs? $820. Now, you also, we get to the misdemeanor part of it. You also understand that DUI is enhanced. Get another DUI can be more, punishment can be more harsh. You need some time to pay the fine.
Yes, Your Honor.
I want to pay you $75 a month. First payment will be due 30 days from today and 30 days thereafter. So it's paid. Okay?
Yes, Your Honor.
You need to meet with probation parole officer right over there.
Yeah, let me make it for you.
John Lynn, John. Commonwealth, Kentucky versus John Lynn, 24 CR 0038. You are John Lynn. So born in 1991. Sir. Last 4 digits of social security number 4238. So here for the purpose of arraignment, you have the right to remain silent. Okay. Any questions, step away and talk from Mr. Defendants. The grand jury of Cumberland County returned an indictment charging you with unlawful possession of a weapon on school property, tampering with physical evidence. Criminal trespass. The alcohol intoxication and other things. Mr. Poindexter, you acknowledge the identity of your client, received indictment, away formal reading and arraignment, enter plea of not guilty, reserving all pre-trial motion.
I do, Your Honor.
Senator reciprocal discovery order here. You're next to be here on at 1 o'clock on July 31st. And the next court appearance is August 29th. And before we go farther, Mr. Stockton, what's the deal here on the weapons charge?
Evidently, there was some kind
I
of
can't hear you. I'm sorry.
incident with the police and they accused Mr. Lynn of trying to hide a weapon near school grounds, on school grounds.
He was taking a shortcut, Your Honor, at night across the elementary school property when he was approached by the police and he had a weapon. And so he had set it aside,
Allegedly.
allegedly.
Well, you're not to be around any weapons. You understand what I'm saying? Is that a condition of his bond?
Understand?
Pre-trial? Pardon?
$1,000 cash.
Is he to be around any weapons? It's a question. That's the added condition of his bond. He's not to be around any weapons. And I want you to, look very
I'll
carefully.
talk to the officer or whatever.
Yeah, I'm not in tendency to be very lenient on people that are trespassing around a construction zone or committing any crime and got a weapon on them. It's a little rough. I'm not saying you did it or didn't or whatever your reason was. So you got those 2 dates. Whatever the condition of your bond is, it'll be added that you aren't to have any weapons on you until this is resolved. You understand? Okay, thank you. Okay, Joseph Massey. Thank you. Commonwealth versus Joseph Massey, 24 CR 0035. Are you Joseph Massey?
Yes, sir.
You born in 1957?
Yes, sir.
The last 4 digits, your social security number 5077.
Yes, sir.
You're here for the purpose of arraignment. You have a right to remain silent. You're represented by counsel. The grand jury of Cumberland County has returned an indictment charging you with trafficking in controlled substance in first degree oxycodone, possession of controlled substance, methamphetamine, possession of drug paraphernalia, operating under the influence, possession of substance not in the original container, possession of marijuana, no brake lights, and failure to signal. Do you understand those charges?
Yes, sir.
Great. Mr. Poindexter, you acknowledge the identity of your client, received indictment, waive formal reading and arraignment, enter plea of not guilty, reserving all pretrial motions.
I do, Your Honor.
Sign a reciprocal discovery order here at Plaza Commonwealth, sir, to give you all the information concerning your defense to help prepare. You'll next be here for negotiation at 1 p.m. on July 31st, and the next court appearance is August 29th at 9 a.m. And both of those are conditions of your bond. Okay? Commonwealth versus Michael Neal. Michael Neal. Commonwealth versus Michael Neal, 24 CR 0026. Are you Michael Neal? Are you Michael Neal?
Yes, sir.
Okay, you born in 1971.
Yes, sir.
Last four digits, social security number 9811. Do you understand? Is that right?
Yes.
You're here today for sentencing. Have you had an opportunity to look at the pre-sentence investigation report done by probation and parole?
Yes.
It's substantially correct.
Yes.
Counselors, any reason this gentleman should not be sentenced today?
No, Your Honor.
On a plea of guilty to wanton endangerment first degree, you shall receive a sentence of 5 years probated for 5 years. And it says, Mr. Stockton, in the plea agreement, that he was currently incarcerated and shall remain incarcerated until.
Well, when we did the plea papers, in between the time we did the plea papers and the plea, the victim came in and signed his bond and got him out.
And Judge, you allowed, when we entered the plea last rule day, you allowed Mr. Neal to remain out of custody pending sentencing.
I was just gonna say, is that gonna change your position on the number of days and so?
Now, my understanding is he's been out. He lives next to my staff. He's been doing well. I hope he keeps doing it.
Just wanted to make sure.
Thank you, Mr.
You
Stockton.
should have credit for time served. So the probationary period will be for 5 years. You can take the probation and parole right back there. Court cost is 185. Was there there wasn't a DUI?
No, Your Honor.
Okay. Okay,
Yeah, he played in district court.
okay. Okay, you go meet the probation parole. William Allison,
Yeah.
pay $30 a month. First payment,
Michael.
$30. Pay $30 a month toward your court costs. Okay.
You know.
Stacy. Thank you. William Allison. Come over versus William Owsley. Are you William Owsley?
Yes, sir.
You born in 1993?
Yes, sir.
Last four digits, social security number 1996. You're here today on 24 CI 0010 on a pretrial conference. Says you're represented by public advocacy.
That's correct, Your Honor. We have a pretrial diversion plea,
Okay.
and Mr. Stockton is signing the documents.
As you heard, your attorney has just announced that you wish to enter plea today. Is that correct? Are you currently under the influence of drugs or alcohol?
No.
Okay, is this plea freely and voluntarily given?
Yes, sir.
You just previously been identified in this indictment. Are you the same person?
Yes, sir.
Have you discussed this matter with your attorney and are you satisfied with his advice? Is your judgment impaired today in any way?
No, Your Honor.
Okay. You believe you're fully informed about your case? Now, before I can accept a plea, I need to know that you understand your rights under the Kentucky and United States Constitution. You have a right not to testify. No one can make you say anything. You have a right to speed trial by jury. You have a right to be represented by counsel at your jury trial. The right to confront and cross-examine all witnesses called to testify against you. The right to produce evidence, the right to call witnesses in your favor, right to bill a matter to higher court if you lose, and right to require the Commonwealth to prove beyond a reasonable doubt that you're guilty of charges against you. Understand that by entering guilty plea, you have a right to give up all those rights. You understand that?
Yes, Your Honor.
I may consider the Commonwealth's recommendation, but I may apply a range of sentence provided by law. I don't have to accept the recommendation. In the event that I do not accept the recommendation, decide to impose a harsher sentence on you, you have the right to withdraw your guilty plea and proceed to trial. You understand that?
Yes, sir.
And have you previously been diverted in the last 5 years? Have you had a pretrial diversion in the last 5 years?
I don't think so.
Well, I mean, you are hesitant. Have you ever had a pretrial diversion before?
No, sir.
Okay. Do you have any felonies in the last 10 years? Are you currently on probation?
Other than what I'm about to do with this.
You're out on bond on this. Is there any other cases you got probation? Okay. You understand if you successfully complete the diversion program, your case will be dismissed pre-trial diverted. You can have your record expunged. Do you understand that?
Yes, sir.
If you don't successfully complete it, however, you could be brought back in front of the court. I could void it and order a pre-sentence investigation report. You'd be a convicted felon and that could be used against you in the future. You understand that?
Yes, sir.
Okay. Ms. Gordon Anderson, will you read the Commonwealth's recommendation?
Yes, Your Honor. Upon a plea of guilty to possession of a controlled substance, first degree, the defendant shall receive a sentence of 3 years, pretrial diverted for 5 years. Diversion is to be supervised. The defendant agrees to be assessed and follow any recommendations of the social service clinician. The defendant shall pay court costs at the discretion of the court. The defendant agrees to have any and all drug paraphernalia and contraband disposed of in accordance with the laws of the Commonwealth of Kentucky. The defendant shall remain on active supervision until any and all fines and court costs are paid in full or until further request of probation and parole.
Is that what you agreed to?
Yes, Your Honor.
Are you pleading guilty because you did commit the acts charged in the amended indictment?
Yes, Your Honor.
Okay. You're doing so of your own free will, is that correct? Knowing your constitutional rights, I explained to you it's still your desire to give up those rights and enter this plea and allow the court to fix your punishment. Is that your signature on the document?
Yes, sir.
I accept the agreement, sign the diversion order, and you need to meet with the probation and parole officer right there, okay?
Thank you, Judge. Court costs, Judge.
What are the court costs?
215.
215? 15 or 16?
215.
15?
Yes, sir.
$215, you're to pay it $40 a month, the first payment $30, 30 days from today. Kenneth Pulliam. Kenneth Pulliam. Commonwealth versus Kenneth Pulliam, 22 CR 0089. Are you Kenneth Pulliam?
Yes, sir.
You're born in 1973.
Sir.
Last 4 digits of social security number 3449.
Yes.
For those of you that are waiting for Zoom, we just have 3 cases after this. We'll be right with you. Who you represented by?
Well, that's who I wanted to know. We sent both the notice to Trey Wilkerson and to Mr. Pennington because we didn't know who was representing. It's a conflict case.
When have you been in contact with Mr. Wilkerson?
When? Did you say when?
When have you been in contact?
Your Honor, probably a year or two ago. Whenever I was before you.
Do you have enough money to afford an attorney? Where are you working at now?
Part-time working like I was cleaning the boats and stuff.
Okay. Well, I'm going to appoint Office of Public Advocacy. I want you to fill an affidavit in. What are the allegations?
Your Honor, Mr. Pulliam had a DUI fourth. The judgment was entered July the 18th, 2023 here in court. And he was picked up and charged on August the 1st in June. He was stopped by state police and he had multiple charges. No plates, no registration, no insurance, operating on a suspended license, no interlock device. According to the state police, he gave a fictitious operator's license. And he's only supposed to be operating a vehicle with interlock device, and that vehicle didn't have one. So, if we have to have a hearing, I need to get the officer here. I didn't know if anybody would be ready on this case or not. I've got Miss Baker, the probation parole officer, present.
Hey, Judge, given the current appointment, I would ask to please have a chance to speak to Mr. Pulliam to investigate these charges. Sound like all traffic offenses in nature from June 1st.
If they're traffic offenses, they're serious traffic offenses in the Commonwealth. But I didn't have the trooper here because I anticipated this because of the previous representation.
Okay, you be, where are these charges pending here? Come again.
Marion County.
You be back here on August the 29th at 9 a.m. I don't know about this, so.
I don't want him driving if he is.
Well, I mean, I don't know how you keep him driving.
If he's not.
I mean, already he's got 4 DUIs. He's completely ignored all the conditions that go along with those. You step back and talk to your attorney if you want to talk to him. Step back and talk to your attorney there if you want.
So, Judge, again, Mr. Pulliam will not be arraigned to these charges, I think as Madam Clerk said, until Monday. So it's a citation at this point. He's not even been properly arraigned by Byron District Court. Secondly, Judge, he tells me that he was in a position where he wasn't required to have an ignition interlock at this time. So I think those charges will need to be investigated by the Byron District Court. The fictitious or the misleading part, he provided a old driver's license and that was the basis for fictitious information, which it was correct. It just wasn't valid. So hold on, let me talk.
I don't even know whether I want you riding in the car, much less not driving one, I will tell you, how much time does he have on the shelf?
5 years. DUI 4.
Well, we'll see how that goes over there in Barron County. Don't you be driving a motor vehicle.
Yes, Your Honor.
Maybe we ought to put an ankle monitor on him and just work church with the doctor.
Well, I want him work church and the doctor conditions on his bond. Put a bond on him. Work church and the
You
doctor.
can just order that through probation.
I don't think you can afford an ankle monitor, can you?
Not right now.
Okay, well, you stay at home, you go to work, you go to church, you go to the doctor. I don't want you out gomming around and drinking and stuff anywhere. You understand what I'm saying? Yes. Okay.
Judge, if I may, we have no objection to those conditions, but I don't know that a bond, I don't think Mr. Pullen is on a bond that turns
Okay,
on.
but
I'm not asking for a bond,
Take
Judge.
him
I'm just,
into-
no,
take
no,
him in-
Judge, we're asking.
Well, I can do that. I can put him in custody when you're back, or he can go on a bond. If you don't think I have the authority to put him on bond, then he's in custody.
Judge, that's not what I said. Judge, could Mr. Pullen be put on a surety bond with those conditions? Is the defense's request at this time?
I'll let him sign an ROR if he wants to with those conditions. I don't care how he gets on the conditions. I'm not trying to do anything to him. I just want him on the conditions now.
And
So
that's how we were
let him
trying.
make an ROR bond on this thing.
Yes, Your Honor. Thank you.
I just recognize.
Wait a second. Yeah, you need to sign that DUI guilty plea.
I'd just like to recognize Miss Baker to be back here on August the 29th, Your Honor. For a hearing.
Ms. Baker, if you'll be here on August the 29th.
Yes, sir.
On his last DUI.
Okay, so there's no. Okay.
I'll let you have a copy of that to review.
Yeah, Judge, I'm not comfortable having him
I
execute
understand.
DUI guilty form on the fly.
I understand that. Just make a copy of that.
Yeah. You would do that motion.
And we'll go back and pull the tape on it, see.
I was gonna say, Judge, that's from
understand.
2022. That
I
predates my
I
contract, so
I
I need to.
understand that. Melissa Thurman. You need to go downstairs and sign the ROR bond. Can you prepare it for him downstairs?
Yes, sir.
Down-
I'll call downstairs.
Go downstairs and they'll provide an ROR bond with those conditions on it, okay?
Yes, Your Honor.
The clerk downstairs, okay? Melissa Thurman. Are you Melissa Thurman? Yes. You born in 1974?
Yes.
Last four digits, social security number 6854.
Yes.
You're on 24 CR 002025. Is that right?
Yeah.
You're here for a pre-trial conference. What do we have?
Judge, we had negotiated this one about 2 months ago. We did not have a negotiation prior to this day. I discussed with the Commonwealth and I've tendered some medical proof. I will note that it's not certified. So I think I would request another negotiation pretrial.
We'll either resolve it or get a trial.
Do what?
We'll either resolve it or get a trial.
Okay, July 31st at 1 PM here for negotiation and August 29th here for your next court appearance. Sean Wadley, is that correct? Sean? Sean, how do you pronounce your last name?
Wadley.
Well,
You was dead on that, good.
I got my consonants correct there for the change. This is 24 CR 0031. Are you Sean Wadley?
Yes, sir.
You born in 1972?
Yes.
Last four digits, social security number 9513.
Yes, sir.
You're here today for the purpose of arraignments. You have a right to remain silent. Grand jury of Cumberland County has charged you with trafficking a controlled substance in the first degree. Possession of controlled substance, methamphetamine, possession of drug paraphernalia, failure to maintain insurance on a motor vehicle, operating under the influence, no registration plates, expired plates, careless driving, and speeding. You acknowledge the identity of your client, receipt and out, and away formal reading your arraignment, and plea not guilty or serving all pre-trial motions.
Yes, sir.
I'm signing a reciprocal discovery order here. This means the Commonwealth has to provide your attorney with all the evidence that they have against you to be able to prepare your case. What kind of bond conditions does he have?
Your Honor, I signed him up for ACR this morning. He's brought the no further violations of the law, not to consume any alcohol or illegal drugs, to report the pretrial was directed, and he is also to call into our office on Tuesday of each month.
Do you have a job anywhere?
Yes,
Where do you work?
self-employed. I have my own company. That big plumbing.
He's out of Georgia, Your Honor.
Are you a Georgia resident?
Yes, sir.
Yeah, I want a reciprocal discovery order, so I mean, I would sign. You know, you got one of those over there? Yeah, waiver extradition.
Judge, we also filed or gave proof of his registration and his insurance.
We'll take care of that later. You raise your right hand, sir. You acknowledge that you'll come back to Kentucky and won't make us send a dog after you.
Yes, sir.
Okay. You get one of those and have him sign that.
Yes, sir.
Do you want him there for negotiation day?
Yeah, he's up here. Is he living here now?
No.
But
Well, I think it'd be fair, but maybe he's got to come back from North Carolina. He's up here, so he's gonna be present.
that's what I was telling you, I have to call him, and he said, I'll be gone all next week.
Well, let Mr. Bell and I set up the time between now and the 29th.
Okay, you'll be back here on August 29th at 9 AM for your next court appearance. And your attorney will set up a negotiation day with the Commonwealth. The last one before we go on Zoom, Paulette Wilson. Paulette Wilson. Commonwealth of Kentucky versus Paulette Wilson, 24 CR 0019. Are you Paulette Wilson?
Yes.
Were you born in 1974?
Yes, sir.
The last four digits of social security number 5611.
Yes.
We're here for sentencing 24 CR 0019. Have you had an opportunity Have you had an opportunity to review the pre-sentence investigation report done by probation and parole?
Yes, Your Honor.
Is it substantially correct?
It is, Judge.
Upon plea of guilty possession of controlled substance, first degree defendant shall receive a sentence of 3 years probated, 5 years supervised. When it agrees to be assessed with social services, the following your recommendation or the court health. Need some time to pay that, man.
Yes, sir.
Okay, I'll let you pay it at $50 a month, okay? First payment due 30 days from the day and $50 a month, so it's paid for, okay? Then we can make the probation roll. Okay, is Lee adjustment, okay, Lee adjustment, are you on there? Lee adjustment, we had Commonwealth versus Michael Carroll.
Yes, Your Honor.
Could you turn your camera on, please?
Yes, Your Honor.
Helmets on.
It's trying to load right now.
Okay.
There it is.
Commonwealth versus Michael Carroll, 24 CR 0012. Are you Michael Carroll?
Yes, Your Honor.
We're here for a pretrial conference. Your attorney, Mr. Pennington, is here. What does the Commonwealth have to say?
We have a felony plea, Your Honor.
Mr. Carroll, a motion has been filed that says you wish to enter guilty plea today. Is that correct?
Yes, Your Honor.
Under the influence of drugs or alcohol?
No, Your Honor.
Were you freely and voluntarily given?
Yes, Your Honor.
Were you the same person named in indictment number 24 CR 0012?
Yes, Your Honor.
Judgment impaired today in this way. Is your judgment impaired? You know what's going on here?
Yes, Your Honor. My judgment's not impaired. No, Your Honor.
Are you satisfied with the advice of your attorney?
Yes, Your Honor.
Have you reviewed the evidence the Commonwealth has against you? You believe you're fully informed about your case?
Yes, Your Honor.
You understand that you do not have to enter guilty plea today. You have certain rights under Kentucky and United States Constitution. Before I can accept the plea, I need to know that you understand those rights. I'm going to go over them with them at the end. I'm going to ask you if you understand them. You have the right not to testify. Same thing. You have a right to speak trial by jury, the right to be represented by counsel at the jury trial, the right to cross-examine all witnesses called to testify against you, the right to produce evidence, the right to call witnesses in your favor, the right to appeal this matter to higher court if you lose, the right to require the Commonwealth to prove beyond a reasonable doubt that you're guilty of charges against you. Understand it, but entering guilty plea today, you give up those rights. You understand that?
Yes, Your Honor.
And I may consider the Commonwealth's recommendation, but I may apply any range of sentence provided by law. I don't have to accept any recommendation. Prior to accepting your recommendation, I will await the pre-sentence investigation for probation and parole. In the event that I do not accept the Commonwealth's recommendation, inside of impose a harsher sentence, you have the right to withdraw your plea. Mr. Stockton, will you come to the podium and tell us what your recommendation is?
Yes, Your Honor. Upon a plea of guilty to trafficking in a controlled substance, first degree, first offense, and persistent felony offender, second degree, the defendant shall receive a sentence of 17.5 years to serve. The Commonwealth opposes probation and shock probation. You'll receive credit for time served, and all evidence in this case will be destroyed.
Mr. Carroll, is that your understanding of the Commonwealth's recommendation?
Yes, Your Honor.
Okay. Are you pleading guilty because you didn't commit the acts charged in the indictment?
Yes, Your Honor.
Knowing your constitutional rights explained to you, still you desire to give up those rights, enter plea of guilty to charges, allow the court to fix your punishment.
Yes, Your Honor.
They said by entering this guilty plea, any future convictions of felonies could be enhanced under persistent felony offender law. You understand that?
Yes, Your Honor.
You got the.
Judge, if I may, the plea agreement, Madam Clerk has that, and also, Judge, I don't want to jump the gun a little bit, but Mr. Carroll is a state inmate, so he may be eligible to waive PSI, which is his wishes and intentions, if eligible.
There you go. Is that your signature there, sir?
Yes, Your Honor.
Okay. I'll accept the plea. I've been informed by your attorney and verified by corrections that there's no reason to do a pre-sentence investigation report because you are presently a state prisoner. So I'll waive it and enter the verdict, okay?
Thank you so much,
very
Your Honor.
much. Thank you. Lee Adjustment Center, you are excused. We'll go to Shelby County Detention Center. Shelby County Detention. I'm waiving the court costs on Mr. Carroll. Mr. Pennington, did you get that as a waiving the court costs?
Yes, Your Honor, thank you.
Shelby County, are you on there?
Judge, if I may, is the Shelby County defendant Raymond Miracle?
He is.
Okay, Judge, I'm entering my appearance for Mr. Miracle. He was actually transported on a bond furlough yesterday from, I believe, Adair County or Shelby County to Life Restoration Center in Corbin. He's on the screen now. And for his further court dates, we can arrange for transportation from the rehab to here, but he was just transported on that bond furlough yesterday.
Commonwealth versus Raymond Miracle. Are you Raymond Miracle?
Yes, sir.
You were born in 1968.
Yes, sir.
Last four digits, social security number 2538.
Yes.
You're here today for the purpose of arraignment. You have the right to remain silent. The grand jury of Cumberland County, the grand jury of Cumberland County has charged you with possession of a handgun by a convicted felon, possession of drug paraphernalia, disorderly conduct, failure to maintain insurance, failure to notify the Department of Transportation of arrest, change, careless driving, being a persistent felony offender. You understand those charges?
Yes, sir.
Counselor, you acknowledge your receipt indictment, waive formal reading and arraignment, enter plea not guilty, reserving all pretrial motions.
Yes, Your Honor.
Okay, I'm signing a reciprocal discovery order. Now, what is, I don't really agree with, this case. How is it that he's sent to the, rehab from Shelby County?
Judge, he has a.
Wait a second.
Your Honor, he's on my caseload for a Hardin County case and a Shelby County case. He had multiple cases going at once. He made bond on those other cases. I think Shelby County yesterday released him to treatment on what they're calling a furlough. He's not state inmate, so it's not a furlough, but it's like a bond condition for them. But they did transfer him to a treatment facility that he's currently at.
What's his bond here?
$45,000 sure posted.
Is he posted already?
Yes.
That's what the trial schedule coming up to.
Do what?
Yeah, so the trial schedule coming up for Shelby County as well.
What are those charges?
They're extensive, Your Honor. I'd have to dig it up.
I posted a cash bond in Shelbyville and then they furloughed me to this.
Okay, July 31st for negotiations at 1 p.m., August the 29th, 9 a.m. here in Cumberland.
Thank you, Judge.
I want, as long as he's there at the rehab, it's fine. If he's not at the rehab, he'll be confined to home, work, church, or the doctor as part of the bond condition, okay?
Yes, Judge, thank you.
Okay, thank you very much.
Thanks, sir. Am I excused?
Yes, you are, thank you.
All right, thanks, sir.
Hart County Detention Center.
I guess I'll get in touch with him.
Commonwealth of Kentucky versus David Hammer. Are you David Hammer? David Hammer? Are you David Hammer? The microphone is off. Somebody, you need to push the microphone, the little red microphone button there. There you go. Are you David Hammer?
Yes, sir.
Okay, you're here on 23 CR 0027. Were you born in 1987?
Yes, sir.
What is it? Social Security number 2512.
Yes, Your Honor.
Probation revocation. What's the Commonwealth say?
Your Honor, he has a 12-year, 6-month sentence. He's on probation, and since May of 22nd, he had a shoplifting charge in Hardin County. Then on June 6th, he has a new felony arrest for going into Rocco Wilson's home, taking his cell phone. He was later caught with the phone and admitted that he took it. And so he's had those, and Officer Dyer's online. We can put on testimony if we need to.
And, you know, Judge, if I may, and think Ms. Smith can verify this pretrial, particularly the felony is set for trial. Mr. Hammer vehemently denies those accusations and proclaims that that was his phone that was removed from the residence. And so I don't think there's been a resolution in the shoplifting charges, Judge. So we're not dealing with, in fact, again, allegations, and Mr. Hammer is presumed innocent into proven guilty. I don't have that trial date because I don't represent him in Hardin nor Hart counties, but that is in my conversation, speaking to him yesterday. David, I don't need you to say anything.
It's a misdemeanor charge.
Oh.
What?
It's misdemeanor reporting.
What, the new felony arrest?
The proceedings.
No, it's a misdemeanor charge.
In Hart County.
Mr. Dyer, you know anything about that? What's going on with these cases?
That's my bad on the new felony. I was going under the old rules. I just looked at the $500, between 500 and 1,000. I put it as a felony. I forgot that they raised the limit. So that is a misdemeanor charge.
You can get revoked on misdemeanor charge, you know.
Well, what concerns me is that the allegations are he went in this person's house too.
I was living there, Your Honor.
There are allegations at this time.
Wait a second. Raise your right hand, Officer Dyer. Officer Dyer, raise. Swear testimony about gives the truth, whole truth, nothing but truth.
I do.
Just explain what's going on here in this.
Yeah, Mr. Dyer, how long have you been supervising Mr. Hammer?
I got his transfer in the middle of February of this year.
And since that time, has he had a job? Has he been in rehab? What's been his status?
I don't remember if he's been working. I don't believe he was working. And I think he was going to outpatient treatment. However, previously he was suggested that he go to inpatient treatment, and he had left on his own accord.
Was that the Phoenix project?
Yes.
And that was back in November of last year?
Correct.
Okay. Has he had any failures to report?
He's shown up eventually. He hasn't shown up on his days, but he did not have any failure to report for me. He failed to report was directed, but he still showed up those months.
Okay. After he left the Phoenix project, you've got in your report, February 6, 24, did you have him go to any other treatment?
I believe he was going to Bluegrass on his own. When I got him, he was already enrolled in Bluegrass.
Okay. Now, how did you learn about these two misdemeanor charges that Mr. Hammer has?
I got an email from the Justice Exchange hit that he had been arrested.
Okay. And did you get a warrant on him for that? How come he's lodged in jail now?
Yes, I did. I requested a warrant for these new charges.
Okay. Have you put a pin in on him yet? Does the
No.
state say?
No.
Okay. I don't have anything further.
If I may, Your Honor. Officer, when you initially put in your violation, was that based on felony charges?
That was based on the two arrests. The fact that he had been arrested and then about 3 weeks later, less than 3 weeks later, he was arrested again.
And you noted in your violation report felony charges, correct?
I did, yes, that was my mistake. Yes, sir.
And as we have learned today, in fact, those aren't felony charges.
It is not a felony charge, no.
Do you have any information regarding these charges other than what was provided to you by Justice Exchange?
Mr. Hammer stated that that was his phone. He had been talking with his girlfriend, who was also at the his previous counselor, I believe. He said that that was his phone, and he had moved in with her, and then her brother showed up, and he was staying there, and he came to get his phone, but I'm not sure on the accuracy of whose phone it was or anything like that.
Because you testified, you're not sure on the accuracy of whose phone it is.
Correct.
That'd be something for courts to sort out, correct?
He's what?
That would be something for courts to sort out, correct?
Yes, sir.
You talked about Mr. Hammer already being in treatment when he came to see you in February,
He was, yes.
and he's continued into treatment until the arrest warrant in outpatient setting.
I'm not entirely sure on the extent of his treatment. Like I said, it turned out that he was dating the counselor at the treatment program, so I don't know how great that was, and how accurate the reports are. I'm not sure.
Well, because you testified dating and living with a counselor at a rehabilitation facility, right?
With the person he was living with previously worked at the Bluegrass Counseling where he was going, but she had been terminated against, I'm not entirely sure, but I believe it was allegations of them being together, her dating a client, but I have no idea on that. But yes, he did move in with her.
Usually frowned upon to be.
And you, sir, or officer, you weren't sure about Mr. Hammer's working status. I think you said, I don't believe, or I think, you're not sure, you think testifies to that?
I could go back and check his release reports and see if he has anything listed.
That's okay, officer. And then finally, just to your knowledge, is Mr. Hammer enrolled in college courses in Glasgow, Kentucky?
I don't know on that.
Certainly as his officer, would that be something that you would know or have access to?
Not necessarily unless he reported it. But then again, we don't really check into a lot of times if they are enrolled or not.
Thank you. Those are all the questions I have. Sorry. I didn't mean to cut you off.
I don't know. I'd say, if they tell us that they're enrolled in classes, we'll say that's great. Continue on, keep doing what you're doing.
Mr. Stockton,
I don't have any reader.
you have any, put anybody on?
No, Judge, I feel the officer adequately summarized what testimony Mr. Hammer would give. Judge, if I may, again, I will stress, the officer saying, I don't really know who to believe, and these are allegations of a phone, now misdemeanor charges that again have not been properly resolved.
I'm fine putting a pin on him, leaving him in custody and see if he can beat these charges. I'm confident if he beats the charges the way he's going, he'll be back in front of us anyway, so I'm patient.
Could you go ahead and put a pin on him? Make sure he's a state prisoner, he's not on the county's dime here. Dyer.
Is he receiving a sanction or what?
Whatever you have to do.
You do the 90-day sanction, a little revocation, and then bring it back when these are over with. Surely that if there's nothing to them, they'll be resolved in 3 months, surely.
Well, I don't know.
Judge, I would object to a
I
sanction.
don't know whether I can do 90-day in lieu of revocation, and then if he gets guilty on these things, then revoke him again, you know what I mean?
I see what you're saying.
Court would be inclined to sanction. I'm sure Mr. Hammer would certainly.
I'll just go ahead and leave him in on the county dime then, and we'll have him come back here on August 29th.
Yes, Your Honor.
Take it under advisement until we see if there's any resolution there. Barron County. Barron County. Commonwealth of Kentucky versus Richard Armstrong. Are you Richard Armstrong?
Yes, Your Honor.
You're here today for the purpose of sentencing in 23 CR 00080. Were you born in 2000?
Yes, Your Honor.
What is it? Social Security number 7619.
Yes, Your Honor.
Have you had an opportunity to look at the pre-sentence investigation report done by probation and parole?
Yes, Your Honor.
You were pretrial diverted, and that diversion was voided on April the 25th, 2024. So you were sentenced to 3 years. I've reviewed it. Is there any reason you want to make a statement about this?
Judge, I made an objection on the record last time. I will just continue my objection. Mr. Armstrong has a pending case, I believe in Metcalfe County. I think that was on pretrial, sometime this week. I don't know the result of that pretrial conference. But it's my understanding that in that case and in that litigation, it was contemplated on him undergoing competency and capacity evaluation. Just from my argument standpoint, I just do want to note for the record, I have reviewed the pre-sentence investigation with Mr. Armstrong. I'm not confident that he understood what we were going over. And I made that same statement on the record last time. I don't change my position. If the court wants to proceed with sentencing, I guess you're doctor.
Well, I certainly don't know whether he's competent or not. I know what we've agreed to, and I know that he entered a plea and we revoked him based on allegations. So it's up to the court if you want to have him evaluated before we have him sentenced.
And Judge, with regards to revocation, and yes, I will acknowledge that we stipulated to what the officer would have, what was in the citation. That was the court's basis for the pretrial diversion revocation. I'm not trying to ask to go back and unwind that at this point. My objection now is.
I don't know whether I've ever asked. I don't know if he is already stipulated to what he did. Then if he has some sort of mental problem, they can take care of it in correction. It's not like he's entering a plea in the beginning and whether he has the capacity to do that or not. So I'm going to go ahead and revoke him. And then if they want to do some sort of evaluation on him, they can do that. And then he's got the other case pending. Is that correct?
Yes, Judge, and that's outside of this circuit, so.
Yeah, okay, well, if they decide to do something on that, then in corrections takes a look and it's not an appropriate placement for him, I could very well reconsider that. I still have the possibility on a shock, don't
Yes, Judge,
So we
and the
think-
Commonwealth and I discussed that.
Yeah,
They're
we're
very,
going on shock at some juncture if you need something else.
thank you, Judge.
Okay, thank y'all, Barron County, for being so patient. You're really, Mr. Armstrong, your attorney will be over to see you. Let's go to Adair County now.
Thank you, Your Honor.
Thank you very much. Adair County. Tara Dykes. Adair County. Adair County, you got your cameras on? Commonwealth versus Tara Dykes. 24 CR 0036. Are you Tara Dykes?
Yes, I am.
Were you born in 1990?
Yes, I am. Yes.
Last 4 digits, social security number 4550. You don't
Yes,
have,
sir.
you don't have an attorney list, Ms. Dykes.
That's correct, Judge.
Okay, well, I'll continue the appointment of Mr. Pennington to represent you from your district court appearance. You have a right to remain silent. You're here for the purpose of arraignment. If you have any questions, I can have your attorney give you a ring on this thing, okay? The grand jury has returned an indictment charging you with theft by unlawful taking or disposition of more than $10,000, theft by unlawful taking or disposition of more than $1,000, operating under the influence, driving on a suspended license, being a persistent felony offender on the first 2 counts. Counselor, you acknowledge the identity of your client, receive the indictment, waive formal reading and arraignment, enter plea of not guilty, reserving all pretrial motions.
Yes, Your Honor.
You have signed a reciprocal discovery order. Requires the Commonwealth to provide information to you to help you prepare for your defense. We will set a negotiation date on July 31st at 1 p.m. here. If you want your client here, you need to do a transportation order. Next court appearance on August 29th.
Judge, if I may very briefly, I'm showing Ms. Dykes has a $10,000 cash bond. I understand the nature of particularly the C felony. Speaking with her, I understand that evidence is scant at best.
I wouldn't know about that. I don't know about evidence because.
And Judge, we would be asking, and
Say.
I looked and I didn't run her through NCIC. I don't have that ability. In my inquiry, I'm not exactly sure that Ms. Dykes is a persistent felon in the first degree. She may qualify for PFO 2. I could be wrong on that. I did an inquiry. So Judge, I would ask that she be granted a surety bond of $10,000.
Commonwealth have to say about here. I understand people bond reduction.
Your Honor, I think she made the statement to the officers that she stole cars for a living, and if you look at her history out of Jefferson County, her criminal history backs that up. She's got multiple felony convictions out of Jefferson County. Her last one was 15 CR 294. Looks like it was 8 years. Assault 2nd degree.
So you're insinuating that you would like a bond hearing?
I would think so. I would be glad to have one, Mr. Pennington.
Yes, Your Honor.
I'll schedule it before the next rule day after you investigate. If you think I'm being too harsh on this bond, then we can.
I'll probably file a motion to raise the bond.
Okay. Okay, well, thank you very much.
I'll be able to speak to you, Tara.
Jeremy Jones. Caldwell versus Jeremy Jones. Are you Jeremy Jones?
Yes, sir.
You born in 1986?
Yes, sir.
Last four digits of your social security number are 8459.
Yes, sir.
You're here on a pretrial conference on 21 CR 0087 and two probation revocations, 18 CR 0077, 19 CR 0004.
Judge, if I may, I've recently received it with the agent with these cases. The evidence transmission has been a little bit difficult. I just received some KSP body cam footage, I believe yesterday. Haven't had a chance to go over that with Mr. Jones. If we could just get that 7/31 and 8/29 dates, I think at that point,
July
all evidence will be
31st
there.
at 1 PM for negotiation, next court date on August the 29th, 9 AM. Mr. Jones, I don't know whether you could hear that or not, but your attorney said that he just received some additional information that he thinks he needs to review with you, so you'll be fully informed about what you're dealing with. So I'll grant this continuance that day, okay? He'll be up to see you. Thank you.
All right.
Thank you. Joanna Kittrell. Joanna Kittrell. Well, good morning, Ms. Kittrell.
Good morning.
24 CR 0027. Ms. Kittrell, you born in 1997?
Yes, sir.
Four digit social security number 0105. Now there's a question about competency.
Yeah, are you gonna stipulate or do we need a hearing?
We need a hearing.
Yeah, if we can pass this, we'll try to get Dr. Anderson on the line. We subpoenaed him, but I don't think he's been sent a link this morning.
We'll be getting back to Ms. Kittrell's case at the end of the docket so we can get the doctor online to interview her. So you'll just have her available. Larry Minge. That's how you say the last name. Minge. Larry Minge. Ms. Kittrell will call your case and back up in just a minute. Okay. We gotta get to the doctor on the line, okay?
Okay, thank you.
Larry Minge.
Yes, sir.
The Commonwealth versus Larry Minge, 24 CR 0034. Mr. Minge, you were born in 1963.
Yes, sir.
What are the last four digits of your social security number?
3673.
Thank you. We're here today on a pretrial conference. What do we have?
Your Honor, we were waiting on a lab report and we just discovered that it only recently been sent to the lab. So it may be another month before
What's
we
he
get it.
charged with?
He's charged with trafficking. The lab has come back on the
You have to
DUI.
get to the microphone, sorry.
The lab has been returned on the DUI, but for some reason the evidence wasn't
What was the
sent.
quantity?
Uh,
This was a quantity charge.
quantity, well, it was almost a gram and a half of heroin. And I was looking to see if they listed anything else in the report.
Judge, if I may, while Mr. Stockton's looking at that, the blood sample that was returned, I'm gonna try to mitigate the results. They were amphetamine, methamphetamine, and 11-9 marijuana, THC.
Have a cocktail, right?
Well, Judge, what wasn't in that cocktail or the absence is the heroin. I think that is a large basis in, if I'm speculating, if I may, into the court's conversion from a surety $25,000 cash bond and then amended to a cash bond. I don't know the quantity, but Judge, I think that is also predicated on what the lab says. I would ask.
It could be that he took all those other drugs, but he doesn't like heroin. He sells heroin. It could be that.
And also 59 grams of methamphetamine too, so they did.
59 grams.
So there may not have been any heroin, that's. May not be any meth yet, we don't have the lab back.
Let's say once one of the famous characters on TV used to say, Mr. Finnegan, never mind.
Judges, and I know the court's position on bond motions. I'll be very brief on this, but
You want to reserve your bond motion until you can have a hearing at the next talking to him? Or do you want to use it up now?
Judge, that's the precarious situation I'm in. If, with the absence of having the labs, I could have arguments relating there, or I don't know what, I'm still waiting, and that's.
I'm just trying to give you some cover, Mr. Pitt.
I understand, Judge, and I've discussed this with Mr. Minji, and Judge, under fundamental fairness, I don't believe he should. If he was exhausting his one bond motion.
I'm not saying I won't give you another one.
What is his bond name?
It's $25,000 cash.
Well, can you make a 50,000 property?
Larry, you got anybody that can post a property bond for you?
Not 50,000. No.
Judge, I believe he's out of state, Tennessee.
Well, he might have some customers or friends or something.
Judge, I don't know if an ankle monitor would, certainly at the very bare minimum, I know Mr. Minji would exit.
You can talk to Commonwealth about it. I'll let you keep the bond situation open if you have any people you want to call at a later date. Okay?
Yes, Judge. I'll be able to talk to you, Larry.
All right, thank you.
Raymond Oliver.
He's got big.
Commonwealth versus Raymond Oliver, 22 CR 00108. Mr. Oliver, were you born in 1969?
Yes, sir.
Last four digits of your social security are 1975.
Yes, sir.
It looks like we're on the revocation of a pretrial diversion. What is this?
No, this is the entry of a plea, Your Honor.
Well, it had the pretrial diversion on here, so.
He does not unfortunately qualify for that in this case, Your Honor, so we'll have.
I know it's on the docket. Note the mistake by the clerk's office. Okay, this is 22 CR 00108.
It's Your Honor.
Mr. Oliver, a motion has been tendered that says you wish to enter a plea today. Is that correct?
Yes, sir.
I'm sorry for the mistake on the docket. I didn't think the same thing incorrect there. Are you currently under the influence of drugs or alcohol, sir?
No, sir.
Please freely and voluntarily given.
Yes, sir.
Are you the same man that was identified in 22 CR 00108?
Yes, sir.
Is your judgment impaired today?
No, sir.
Have you discussed this matter with your attorney? And are you satisfied with her advice?
Yes, sir.
Review the evidence the Commonwealth has against you and you feel like you're fully informed about your case.
Yes, sir.
You have certain rights under Kentucky and the United States Constitution. Before I can accept the plea, I need to know that you understand those rights. You have a right not to testify against yourself. No one can make you say that. You have a right to speak trial by jury, the right to be represented by counsel at your jury trial, the right to confront cross-examination. All witnesses called to testify against you, right to produce evidence, right to call witnesses in your favor. Right to appeal this matter to higher court if you lose. Right to require the Commonwealth to prove beyond a reasonable doubt that you're guilty charged against you by entering a guilty plea. You give up all those rights. You understand that?
Yes, sir.
I may consider Commonwealth's recommendation, but I may apply any range of sentence provided by law. If I do not accept the recommendation, after reviewing the pre-sentence investigation report, citing your hardship and punishment, I'll allow you to withdraw your pleas. You understand that?
Yes, sir.
Who's doing the Commonwealth's recommendation?
Your Honor, there will be one charge of sodomy first degree amended to sodomy second degree of Class C felony. And then on the remaining charges, other than these pleas, they'll be dismissed. On rape first degree over 12 years of age, it'll be 10 counts, 15 years on each charge to run concurrently for a total of 15 years. On incest, 10 counts, over 12 years of age, be 15 years to run concurrently for a total of 15 years. On a plea of guilty to sodomy, first degree, he'll receive 10 counts, child over 12 years of age, he'll receive a sentence of 15 years. All those 15-year sentences shall run currently for a total of 15 years. Then on sex abuse, first degree over 12, he'll receive a sentence of 5 years. On the amended charge of sodomy, second degree, child over 12, he'll receive a sentence of 10 years. The 5 and 10-year sentences shall run consecutively for a total of 15. The 2 15-year sentences shall run consecutively for a total of 30 years to serve. The Commonwealth will oppose probation or shock probation.
Is that your understanding, sir, of the Commonwealth's recommendation?
Yes.
Are you pleading guilty because you did commit the acts charged?
Yes, sir.
In the indictment, is that correct?
Yes, sir.
So of your own free will.
Yes, sir.
Okay, knowing your constitutional rights, I've explained to you that still you desire to give up those rights, and are pleading guilty on charges and allow the court to fix your punishment within the range provided by law.
Yes, sir.
You understand that by entering these pleas, any future convictions could enhance the range of penalty, and that there may be some registration requirements on that too. You understand that?
Yes, sir.
Did you have the plea agreement?
I do, Your Honor.
You can approach Mitch. Is that your signature on there, sir?
Yes, sir.
Okay, I'll accept the plea order pre-sentence investigation report to be done by probation and parole and scheduled sentencing on August the 29th. That should be enough time to get the
To make it at least 60 days.
yeah.
Yes.
That's what I thought too, Your Honor. I explained to Mr. Oliver, sometimes it takes a while, so we may be looking at September.
Yeah.
Yeah, we'll need to do the older, right?
You what?
We'll need to do the oldest. We'll need to do the
I
older.
know I was telling probation and parole to do what they.
Yes, Your Honor, it'll take 60 days for that sex offender.
Okay, Mr. Stockton, September the 19th, be okay with the time? Well,
Yes.
okay, we'll schedule a sentencing on September the 19th. Okay, thank you very much. April Osborne. April Osborne. Commonwealth versus April Osborne, 19 CR 0043. Are you April Osborne?
Yes, sir.
Born in 1984.
Yes, sir.
Last 4 digits, social security number 7623.
It is.
You're on a pretrial diversion revocation. What does the Commonwealth have?
Your Honor, we've got a case going to the grand jury today on her. That's the basis of the revocation. I don't know if Mr. Penny can you hear me? I said, we've got a case going today to the grand jury. That's the basis for the revocation, the possession. I don't know if Mr. Pending wants to handle all that at once, or if he wants to proceed with hearing.
Judge, I have no objection into continuing as represent Ms. Osborne in the case Mr. Stockton's talking about.
You want to set it
We
for
could
the
just-
31st, and I'll send you the discovery.
Let's go ahead and set it for the 31st of July for negotiations, as if the indictment had already been returned.
Yes, Judge.
And then she'll be back here on August 29th.
Case.
Ms. Osborne, they say that they're taking a case to the grand jury that concerns you today. So we're gonna give you an opportunity to advance that sooner than normal. And we'll go ahead and do your negotiation on July the 31st, and next court hearing's on August 29th. And your attorney will be back over there to talk to you about it. If there's any bond conditions or anything that you want to talk to him about, you'll get to talk to him there, okay? Thank you very much. Matthew Riley. Commonwealth versus Matthew Riley. 24 CR 008. You're Matthew Riley.
Yes, sir.
We're in 1968.
Yes, sir.
4 digit social security number 8553. You're here today for the purpose of sentencing. Have you had an opportunity to look at the pre-sentence investigation report of a probation and parole?
Yes, sir, I have.
Substantially correct?
Yeah. Yes, sir.
This gentleman should not be sentenced.
Your Honor, I would state for the record that there's also a more serious case going to the grand jury today on Mr. Riley, so the court may want to hold off on this so we can wrap them all up together. Probation may be moot in this case.
Yes, Your Honor, he had been on for sentencing last month, I think the day after, 1 or 2 days after that charge arose. So we had reset the sentencing until today. It does look like it's proceeding to the grand jury.
Yeah, I don't even know if he's made bond in district court or not.
I don't believe he has.
Do you think it would be in Mr. Riley's best interest to put off sentencing till next month?
At least.
Yes, Your Honor, so we can look at these cases together and.
Okay, they've got another case, Mr. Riley, I don't want you to comment on it, but got another case going to the grand jury today. So this will be put off until, you want a negotiation day?
Yeah, you want to set it next week, or let's just wait on him a little bit, you want to.
Yeah.
It's a little more complicated case, so I think we need to have him arraigned on the 29th instead of negotiation.
Okay, be here for arraignment and then hear this diversion case also on at 9 AM on August 29th. Your attorney will be able to explain what the deal is to you, Mr. Riley.
Thank you.
Yeah.
Not the same.
William Rowe. Commonwealth versus William Rowe. Commonwealth versus William Rowe. Are you William Rowe?
Yes, sir.
Were you born in 1985?
Yes, sir.
Last 4 digits, social security number 6413.
Yes, sir.
You're here today for a pretrial conference. What does the Commonwealth have to say?
We have a felony plea, Your Honor.
Mr. O, you heard the Commonwealth announce that a motion has been filed to allow you to enter a plea. Is that correct?
Yes, sir.
You're currently under the influence of drugs or alcohol.
No, sir.
Is this plea freely and voluntarily given?
Yes, sir.
Are you the same person we just identified in 23 CR 00022?
Yes, sir.
Is your judgment prepared today anyway?
No, sir.
Have you discussed these charges with your attorney and are you satisfied with his advice?
Yes, sir.
You view the evidence Commonwealth has against you and you believe you're fully informed about your case.
Yes, sir.
Understand that you do not have to enter a guilty plea. You have certain rights under the Kentucky and the United States Constitution. Before I can accept a plea, I need to know that you understand those rights. You have the right not to testify against yourself. No one can make you say anything. You have a right to speak trial by jury, right to be represented by counsel at your jury trial, right to confront and cross-examine all witnesses called to testify against you, right to mix evidence, right to call witnesses in favor, right to appeal this matter to a higher court if you lose, and right to require the Commonwealth to prove beyond a reasonable doubt that you're guilty charged against you. Understand that by entering a guilty plea that you give up all those rights. You understand that?
Yes, sir.
I may consider the Commonwealth's recommendation, but I may apply any sentence within the range provided by law. I don't have to accept it. Prior to accepting any recommendation, however, I will review a pre-sentence investigation report to be done by probation and parole. In the event that I do not accept after review that, or do not accept the Commonwealth's recommendation and decide for your sentence, you have the right to require you plead guilty and receive the trial. You understand that? Ms. Gordon Anderson, what is the recommendation?
Yes, Your Honor. Upon a plea of guilty to sexual abuse first degree, victim over 12 years of age, the defendant shall receive a sentence of 4 years to serve. The Commonwealth will oppose probation. The defendant shall have no contact with the victim. The defendant agrees to have any and all evidence to be disposed of in accordance with the law of the Commonwealth of Kentucky.
Is that what you agreed to, sir?
Yes, sir.
Are you pleading guilty because you didn't commit the acts in the amended indictment?
Yes, sir.
Then so your own free will.
Yes, sir.
on your constitutional rights and explain it to you, so you desire to proceed with your plea. Guilty to the charges, allow the court to fix your punishment when they are committed by law. Is that true?
Yes, sir.
You understand that after hearing your plea of guilty, any convictions will be enhanced to the range of penalty and a persistent felony offender law.
Yes,
You
sir.
have- You have the agreement somewhere? Sir, is that your signature there?
Yes, sir.
Well, I'll accept the agreement. Order PSI and a sexual offender.
And yeah, Judge, I think I verified with Officer Dorn that this would be one that would need that, so
September
19th.
19%. Okay, thank you very much.
Thank you, Judge.
Thank you.
Roger Shreve. Lorraine. Commonwealth versus Roger Shreve, 24 CR 0044. Are you Mr. Shreve?
Yes, sir.
Okay, were you born in 1958, sir?
Okay.
The last 4 digits, social security number 7028.
Yes,
You're here
sir.
for the purpose of arraignment. Do you represent Mr. Shreve in district court?
Yes, Judge.
I'll continue that appointment. Mr. Shreve, you have the right to remain silent. If you have any questions, you can inquire with your attorney. I'm just going to arraign you on the charges. The grand jury of Cumberland County has charged you with possession of controlled substance in the first degree, possession of drug paraphernalia, failure to maintain insurance on a motor vehicle, driving on a suspended license, operating a motor vehicle under the influence, and careless driving. You understand those charges? You understand the charges, sir?
Yes, sir.
Okay, I'm signing a reciprocal discovery order. Requires the Commonwealth to give you all the evidence they have in their possession, helping prepare for your case.
And Judge, if I may very briefly,
Let me go ahead and schedule a time. So you want a negotiation date in this case?
yes, Judge.
And negotiation date, of course, July 31st at 1 p.m. and next court date's August 29th. Now let's address the gentleman.
And Judge, if I may very briefly, Mr. Shreve, when I represented him in district court, he was able to post a surety signature bond with the conditions of home incarceration or ankle monitor. He does not have any family here in Kentucky, has been unable to post a surety bond, and Judge, without getting into it, he has a litany of medical problems as he sits there in custody.
Have you talked to Commonwealth about this?
Judge,
I didn't know how long you'd represent the district court.
well, I have been in contact with Mr. Shreve since he was served on the arrest indictment warrant to address those medical conditions, Your Honor.
He signed a waiver of extradition and signed a bond.
I don't think he's out of state. He has out of state family. Is that correct, Madam Clerk? Or is his address? I think it's
Does he live here?
he doesn't live in Cumberland County, but he lives in Kentucky. Cave City.
Yeah, that's fine. Thank you, Your Have him here the 31st.
What kind of bond do you recommend?
I'd say that 10,000, let him sign his own bond.
What kind of bond was he on the district court?
It's $2,500 cash and after the resolution, $1 more.
But did he have was he wearing I thought he had an ankle monitor. I thought that was a condition, but I don't want to misspeak, sorry.
I'll restore it, whatever it was in district court. We'll let you out. Your court dates, you heard them at 31st at 1 p.m. here for negotiations, and August 29th, your next thing. We need to get somebody to hook you up with an ankle monitor. How does he do that?
Junior Smith will need to get back
Well, I
over.
don't see Junior here today.
He'll go to the jail for the voicemail.
Mr. Junior Smith will be up to renew your ankle monitor, Mr. Shreve. You ought to get out soon. Your attorney will give you the dates, okay?
Thank you, Judge.
Thank you very much. Janessa Smith. Commonwealth versus Janessa Smith, 23 CR 00109. Are you Janessa Smith?
Yes, sir.
Born in 1989.
Yes, sir.
Last four digits of social security number is 1768.
Yes, sir.
If you're on pretrial diversion revocation, what does the Commonwealth have to say?
Your Honor, she has a 3-year sentence on possession of a controlled substance, first degree. She's had multiple issues, including overdoses where she's had to be Narcan. She was in the ARC program and was left June the 19th. And our position is probation pro, and ours is if she wants to go and do the PSAP program where she's in custody for 6 months and do that, preserve her diversion, fine. Otherwise, we'd ask for revocation.
Judge, I think that's a very fair offer.
You ought to reconsider that, Mr. Pennington.
I'm being too easy, I guess.
I don't know.
Janessa, I will be over to talk to you about this, but I get your question is they're offering you a chance to do SAP, but you're gonna be in jail while you do it. And that's gonna save your.
May I speak? May I speak?
Sure.
I don't know about the whole Narcan overdosing. I failed one drug test. I've been in jail since November over all this, and then I got the chance to go to rehab, which I appreciate a lot because it helped me get clean. I spent 60 days in rehab and was going to IOP. And I missed the AA meeting and got discharged from there. I come straight home. I stayed clean and I reported to my probation officer. I'm just trying to do the next right thing. As far as I was told is I would do a 60-day sanction and maybe do drug court, which I think I still need. Is there any way possible that you would do that?
Hold on for just a second, please. Judge, if I may, I was tendered a certificate signed by Brooke Rydart.
What about drug court? Shocking.
That's fine. I just thought the lockdown facility would be better because according to the probation parole report, it says over a course of time from November 26, 2023 to February 29, 2024, Smith overdosed and had to be Narcaned on 3 occasions, according to the Dare County jail staff before being released on pretrial diversion. So that was my only concern was I didn't want her to get out and overdose while she was outside. But if she wants to do drug court, I'll do that if that's what the court wishes.
Well, I'm gonna tell you what, I'm gonna go the sanction bit, and then we'll go ahead and sign the referral to drug court. Then they'll vote on you, and then, then you'll get an orientation.
Yes,
Ms.
sir.
Smith, I cannot keep you from killing yourself.
Yes, sir.
Only you can. What I dread all the time is letting somebody out on one of these things and pick up the newspaper and find out that they've overdosed and died, and then you bump into their family and they say, well, why didn't you do more? Well, it comes to the point where the Commonwealth and the defense attorney and the court and everybody else can just do so much, and it's in your hands. So if you think you can do the drug court.
Yeah, I really do think I need that. I have 3 kids that I still have.
There's no question whether you need it. The question is whether you can comply with it and stay clean.
Yes, sir. I have every intention to.
I know. Well, I'm not saying you're a bad person, don't have good intention. I hardly ever see anybody here that's addicted to meth and intended to get addicted to meth. It's just, they just tried it and it happened. So they'll be up to interview you about the drug court then, okay?
All right, honey. Thank you.
Zachary Smith. Commonwealth versus Zachary Smith. Hello, Mr. Smith. This is 24 CR 0048, Commonwealth Kentucky versus Zachary Smith. Mr. Smith, were you born in 1995?
I was.
The last four digits of your social security number, 8147. You have the right to remain silent. The grand jury of Cumberland County has charged you with possession of firearm by a convicted felon, fleeing or evading police, improper starts of a party condition, improper passing, proper equipment, reckless driving, speeding, driving too fast for the traffic conditions, and being a persistent felony offender on possession of a firearm by a convicted felon, fleeing or evading first. You understand those charges?
Sir.
Okay. Counselor, you acknowledge the identity of your client, receive indictment, wait for Reading and arraignment, enter plea not guilty and reserving unto the defendant all pretrial motion.
Yes, Your Honor.
Sign a reciprocal discovery order, Mr. Smith, where they have to provide you all the evidence they have so that you can prepare the defense. We have a negotiation date on the 31st of July at 1 here, and the next court appearance on August 29th.
Zach, I'll be able to speak to you soon.
All right, thanks, sir.
Yep. Commonwealth versus Cody Stinson. Commonwealth versus Cody Stinson. 24 CR 0044. Are you Cody Stinson?
Sir.
Okay, you born in 2004?
Yes, sir.
Last four digits, social security number 8596.
Correct.
We're here today for the purpose of arraignment in 24 CR 0044. And you don't have an attorney listed. Was this a direct?
It's a direct submission, Your Honor.
Have you filled out an affidavit? Can you afford an attorney?
No, sir.
Okay, well, I'm gonna go ahead and allow the Office of Public Advocacy to represent you this time, and I want somebody to send up to the jail and let him do an affidavit, and I'll determine whether he's eligible for the appointment permanently, okay? Yeah, the grand jury of Cumberland County has returned an indictment charging you with rape in the second degree, in sodomy in the second degree, and an unlawful transaction with a minor in the third degree. You understand what those charges are, don't you? Not asking you to get anything, just you understand the charge.
Correct.
I'm signing a reciprocal discovery order, which will require the Commonwealth to give them all the information they have to help you prepare your case. Then we'll, on the 31st of this month, at 1 p.m., you'll be here for a negotiation date. And then on the 29th of August, you'll have your next court appearance. Your attorney will be up to speak to you. Okay?
And if I may, I'm showing a bond at $50,000 surety. Understand the nature of the charges and don't want to make bond motion right now, but I would just very briefly ask if the court be inclined to allow for a $50,000 property.
I'll have to have a hearing.
Yes, Your Honor.
In a case like this, so we'll be glad to schedule one. Your attorney is bringing my attention that he wants to raise his concerns about your bond, but obviously since he just been appointed, he doesn't know enough details, so I'll allow him to reserve interviewing you and come and having a bond hearing if he finds out that he thinks he can and the Commonwealth will be involved with it too, okay? Thank you very much. James Walls. And the Commonwealth versus James Walls. 23 CR 0075. Are you James Walls?
Yes, sir.
You born in 2003? Born in 2003? When were you born, Mr. Walls?
2003, August 7, 2003.
Okay, what are the last four digits for your social security number?
1415.
We're here today on a pretrial diversion revocation of 23 CR 0075. What says the Commonwealth?
Your Honor, he has a 3-year sentence for possession of controlled substance, first degree. He was being supervised by Mr. Garner and he absconded on November the 1st, 2023.
You want to stipulate?
And Judge, if I may, I know the court's position on that A word. Judge, Mr. Walls actually attempted to have his probation transferred to Tennessee, was obviously unsuccessful with that. Spent some time in a rehabilitation center and spent a significant amount of time in Tennessee incarcerated. I'm not gonna.
Over what? What was incarcerated down there?
Judge, I think it was relating to the, I think a warrant subsequent to absconding.
Let's just have some testimony about this.
What?
Let them get the witness stand up here. Let's get the witness.
Let me get the file.
And
You
Judge,
raise your right.
Judge, if I may save the Commonwealth some time, I believe
What
Mr.
about
Walls.
me? You should say me.
Absolutely, Judge, always. Mr. Walls, his problem, and I don't want to embarrass him, but he was essentially homeless when he was in Tennessee. Judge, what he is asking for is actually the chance to complete long-term
Well, I
rehabilitation.
want to know before we.
Okay, yes, Your Honor.
I want to know what he did before we say what he's going to get.
Yes, Judge.
You raise your right hand, you swear to testimony back, give us the truth, the whole truth, and nothing but the truth.
Yes, Your Honor.
Take a seat and identify yourself.
Officer Jeremy Garner, probation and parole.
Officer Garner, were you assigned to supervise Mr. Walls?
I was.
And how did that go?
So he reported to me for intake and he reported at 4 something in the evening. It was really late. And there was one important piece of paperwork, it was his DNA. His DNA that I needed to collect as part of policy. And it was my fault that I did forget that, but I did not rush him back. I called Mr. Walls and I asked him when it was convenient, within a reasonable time frame, could he come back to Kentucky to collect his DNA? And he said he would, and then I never heard from him again. I never seen from him again. And because of that, I could not transfer his supervision. I called every relative, every associate. The person who transported him to Tennessee from my office said that he had stolen from him and he had no idea where he even was from there on.
What day was that intake?
That was, let's see, 10/27, I think,
23?
of 23.
Okay. And so after that date, you never heard from him again?
No.
Okay. Have nothing further, you know?
So Officer Gardner said you had forgot to collect DNA?
Yes, but I did not pressure him to return immediately. That giving him time to make arrangements to get back to me on his own time.
Because James had indicated he had some difficulties with transportation, right?
No, he said that he had utilized a family member to get there and back, and he said it would be no problem to return, but he never returned.
And just so the court has a little bit of clarity, when we're talking about travel to and return from, what part of Tennessee was it that James was planning to relocate in?
Geographically, I don't know the address given. Okay, so the address that was given was deleted whenever his interstate compact transfer got rejected because there was no DNA on file. As far as that goes, I don't have a geographical location for him now.
So just to kind of piece this together a little bit, you had asked him to come in, submit the DNA.
Yeah, I did.
From understanding what you just said, as a result of that inability to collect that sample, the attempted transfer was denied.
It didn't get denied. It couldn't be processed because I couldn't get that. So he was in Tennessee on conditions, allowed to be in Tennessee on the condition that he returns to me. And I didn't rush him. He could have came back in a week. He could have came back in a month. I was willing to work with him, and he just disappeared.
And then you obviously, attempted, as you know in your report, attempted to try to find him, hospitals.
I did.
When you do that search, are you just looking in Kentucky, or does your net cast into Tennessee?
Well, if he tells me that he's living in Salina, I contact Salina. If he tells me he's living in Nashville, there's obviously a lot of hospitals in Nashville, and I don't know if I can reach every single one, but I do my best diligent effort to reach out and make contact with him.
And officer, if James were in a rehabilitation center in Nashville, let's say, would it present that same difficulty in trying to find him?
Do I know where the?
Judge, I think we're getting a little far afield.
Are you aware of any additional charges Mr. Walls picked up in the state of Tennessee?
I can pull them up. Okay. Which arrest do you want?
I guess since we'll use October of 2023 as our baseline, since that's when the supervision began. So are you seeing anything since October of 2023?
Yes, there is a Davidson County booking, a Hickman County booking, a Clay County booking, a Jackson County booking for reckless driving, theft of property. Let's see. He did theft of property over $1,000, theft of property over $500, theft of property over another $500 that he was guilty on.
What was the disposition?
Guilty.
When?
That was 3/20/24.
And just to be clear, you didn't know about it. And I guess until I asked you, did you know about any of this information?
Well, we get notified of this, and then we have a warrant for his arrest. Tennessee has to serve their due diligence before we can get him back to Kentucky for us to honor our piece of that pie.
And again, without an inquiry, you wouldn't know the charges or.
Let's move on.
Judge, I'm just trying to say,
Let's
this
move
is the
on.
quick. Officer Gardner, can you tell us when Mr. Walls would have been in jail in the state of Tennessee?
Look, the issue is he's supposed to come back up here and get his DNA, and he never did. That's the issue. That's the reason this is filed. Is that correct?
That's correct.
And therefore, he was not complying with his probation parole conditions. Now, is that the issue that you're saying?
That's the
So
able.
we
I think
have to
Mr.
wonder
Jenkins
about
made
what-
a great case why other reasons he should be
Yeah,
revoked
I
too.
mean,
But
you're almost piling on your own client here, Mr. Pennington, but go ahead.
But if he was in jail, he couldn't come back. And
Well,
when in the absence of knowing that information,
Well, he was in jail, he violated anyway.
That's what I'm saying.
So, continue.
well, just again,
Continue.
That's not-
Ask your question.
you said you wanted to hear the testimony. I
Go
had said
ahead,
that.
go ahead. I'm allowing you to. Go ahead.
So finally, officer, you can't, or maybe you were about to, within your database there, are you able to tell us what days Mr. Walls would have been in custody in the state of Tennessee?
That was the first arrest that he had since he absconded supervision from Kentucky was March. So that means November, December, January, February, and March 20th. He had 5 months to report to me that he didn't report. And then if I go back from there, it looks like he was transferred. He jail hopped on those same charges from Hickman County. See, April 10th, he was moved to Clay County.
Jason, all that's irrelevant.
And Judge,
All he was in jail at, he said he didn't go till March 20th. That's the answers to the question.
Judge, I know for a question.
You have a redirect.
No, you're not.
Make your statement.
Well, Mr. Walls he had one obligation, and that was to be supervised here in the Commonwealth. He didn't meet that obligation. We made that agreement. He skipped out and left. And then we find out at this hearing, he's on a crime spree in Tennessee. So there's adequate grounds to revoke.
We don't know what those, and again, this is a pretrial diversion revocation. I would certainly reserve any arguments with regards to sentencing, because this is a possession of meth presumptive probation charge.
Yeah, you're exactly right. So I will revoke the pretrial diversion order, pre-sentence investigation report to be done by probation and parole. And we'll schedule this on August 29th, and you can make any motions you have then about probation or that sort of thing, okay?
Yes, Judge.
Thank you. Barry Wilson. Mr. Cross, are you still involved in this case?
I am, Your Honor.
Let me finish.
Yes, Your Honor, we represented Mr. Wilson.
Thank you, thank you.
Commonwealth versus Barry Wilson, 24 CR 0037. Are you Barry Wilson?
Yes, sir.
Okay, you're here for the purpose of arraignment. Your attorney, Mr. Cross, expressed you have the right to remain silent. If you have any questions, we can have him consult. Okay. The grand jury of Cumberland County has returned an indictment charging you with possession of controlled substance first degree, possession of drug paraphernalia, possession of marijuana, obstructed the windshield, improper equipment, and operating motor vehicle with one headlight. You know, Mr. Stockton, these general wording of the indictments don't usually bother me, but on this improper equipment, I don't even know whether these indictments give a person notice what they're even charged with.
I'd rather them be handled in district court. I might just start indicting on the felonies, let them handle everything else in district court. I mean, really.
It's your,
Yeah,
but if we do it, I like enough in there so. we don't-
I understand I dismiss those all the time anyway.
It's with one headlight. We know what it is, but I understand where.
But I understand the
Okay.
court's concerned.
Mr. Cross, you acknowledge the identity of your client receiving the indictment, waive formal reading and arraignment, enter a plea you're not guilty, reserving all pretrial motions.
Yes, Your Honor, we do.
Found to sign a reciprocal discovery order, sir, so your attorney can receive evidence to help you prepare for your defense. Have a negotiation day scheduled on the 31st here at the courthouse at Justice Center on July 31st. Next court date is on August 29th at 9 a.m. Both of them conditions of the bond. Now, what is this gentleman's bond?
Your Honor, here's what we've got. I represent various in district court.
Wait just a second, let me get probation, I mean, pretrial, excuse me.
Yes, Your Honor, I've got that it's 15,000 surety, Your Honor, clerk for surety.
That's correct, Your Honor. He was ROR'd in district court. We represented him there. And I've known Mr. Wilson for years. He works for Kyle's Lumber in Clinton County. And he's no flight risk whatsoever.
Somebody come over and sign up $15,000 surety bond.
He didn't have anybody to sign. That's what we told him. Barry, you don't have anybody to sign, do you?
No, sir, I do not.
Anybody can sign just about $15,000 surety.
Well, I don't. If he'd tell me who to go to, I'd contact somebody, but I don't know who to go to.
Yeah, I'm sorry, I don't have anybody.
Whatever you want to do, I think if it was a valued employee, the policies would probably sign a bond. Houses ain't much to sign for people accused of drugs. Oh, okay. Well, that might be. But, Your Honor, I know Barry, how long you been here? 15 years?
About longer than that, 20, since the early 90s.
Been here a long time. And I've represented him years ago in district court, years ago. Not had a thing since. And he's hired me and.
What were the charges?
It's a possession and a DUI. No DUI, just a possession. Yeah, you're right, it's just a possession. That's like. It's one of those stop for improper equipment and it's
He still have his job?
Well, Barry, will Piles take you back?
Yeah, I would assume, yeah.
Some other sawmill man will.
Where do you live, sir?
I live in Albany.
Where?
We're at 15 Central Union Road.
Yourself or who lives with you?
I live with somebody.
Okay, does somebody have a name?
Yes, it's Johnny Davis.
Okay, do y'all know Johnny Davis?
I know Johnny Davis. We all know Johnny.
Is that okay?
There's at least one person working in the house. Johnny Groff, but Johnny's not going anywhere. Will Johnny come sign your bond, Barry?
Yeah, if you could get up here.
Well, he can go to the clerk's office in Clinton County and sign a bond. I'll take Johnny Davis on your bond and I'll put you, you're restricted to home, church, work as a doctor till we get this finished, okay?
Barry, what's his number and I'll call him.
Don't give him number.
I don't know his number right off the top of my head.
Well, let contact him. I don't want to broadcast the guys.
Can you get a hold of him, Barry?
No, I do not. I don't have his number.
Is it the first house on the left on 415?
Yes, first house right there. It's got an RV in the yard.
Little frame house, right?
Yeah.
Okay, I'll run out there.
Okay.
Thank you.
You got the court dates.
Yes, we did. Thank you.
31st, 29th. Mr. Cross said he's gonna try to get him to come up and we'll accept him on the bond. He just got, it'll take him, he needs to go up to Jake Staten's office over there, okay? To make the bond.
Okay.
Yeah. Cindy Young. Commonwealth versus Cindy Young. 23 CR 0079. Are you Cindy Young?
Yes, sir.
You born in 1959?
Yes, sir.
This 4 digits of your social security number is 6221.
Yes, sir.
23 CR 0079, pretrial diversion revocation.
Yeah, Your Honor, she has a 3-year sentence. She tested positive for methamphetamines on 6/20 of this year. 6/27, she was positive for meth, provided false information to the officer. And the problem with Miss Young is, we can have a hearing, is she needs to go to treatment. But the way I understand it from Officer Garner is he can't send her to the treatments because of the treatment facilities because of the threats she makes against herself and other people.
Okay, come on up here.
Judge, if I may, just very briefly, I think Ms. Young would be a crime candidate.
I want to hear what he has to say.
Your Honor, Ms. Young was participating in outpatient through Ventrust. During a counseling session, she had told her counselor that she was going to hurt someone. And then she said she was going to hurt herself and then abruptly hung up the phone, which caused the counselor to panic. The counselor called emergency services for health and welfare. Miss Young's son is a law enforcement officer here, and he went and checked on her. I got with him the next day and verified that she was okay, but I directed her to come to my office based off of how she was acting, suspicious for her using. She tested positive, denied use, signed a denial that she did not use. I sent that sample to the lab. The lab came back that she lied and she was positive. I retested her. She tested positive again. She signed a admission of guilt form to use the day before I tested her. Took her to the jail, and then she said she was going to hurt herself and hurt others again. They put her in a turtle suit on suicide watch, and I could not get her. I had a referral for her to SSC. I had the SSC lined up to send her to an RKC facility. That stops immediately at the time that she goes on suicide watch, and my hands are tied until they clear her.
And Judge, what I was gonna pray for Ms. Young here is for her be granted the opportunity to participate in the SAP program that Officer Garner had mentioned with Ms. Smith previously. She's still pretrial diverted currently. And Judge, the one requisite for that is pretrial diversion. She's gonna be locked up. I don't know, and I think this will be a them question.
Well, let me take a bite, Counselor. After observing things for a long time, and the Lord has allowed me to live, I've noticed that most people that make multiple threats of doing something themselves have a proclivity for doing something. It's not normal to publicly announce that you're going to do something yourself. I'm worried about this lady. And I don't know if she said this on multiple times. You know, I've got an obligation to protect the public, but also if I see someone that's prone to injuring themselves, then I've got an obligation there too. So I'll be willing to work with this situation, but it seems like she got a terrible drug problem. She's not able to get it under control, and when she gets away from it, I'm sure she does feel like doing something to herself if she comes off this stuff. So I don't know what to do about it. What do you reckon?
Well, I would think if you revoke her and we sentence her, then she's gonna be parole eligible in 2 months. She'll probably be parole eligible by the time she's sentenced. So it might be to the benefit that she goes through this program that's in a facility and gets treatment there.
Well, I'll be willing to sign for her to stay on pretrial diversion and not get revoked if we can get her in an in-house place that she can't get out. How long is the treatment period?
6 months.
I'll do that.
Yeah. And she'll need to realize that she's got to admit that she has a problem because they have their own staff to come down and interview her.
Miss Young, let me.
Yes.
Yeah, let me give you some unsolicited advice, okay? We're trying to keep you from being a convicted felon. And we're trying to help you get off these drugs, okay? These people here aren't trying to do anything to you. They're trying to do something for you. You understand what I'm saying? So if it's obvious to me that you got a drug problem. So when these people come interview you, you admit that you got a drug problem. We'll get you out of that jail there and they'll put you somewhere, you know, not that they don't do a good job there. They treat people kindly there. But we need to get you where you can go home and enjoy the rest of your life that you have. You agree with that?
Yes, sir.
So we're gonna try to accomplish that. And if you do that, you still got time to, I'm not saying you're a bad person. You know, you just got this thing that's got a hold of you. You know what I mean?
Yes, sir.
Okay, well, they'll be bringing the papers up there, and maybe You know, by Christmas time or a little time after, you can be rejoined with your family or after the first year or something, okay?
All right, thank you.
Thank you, Judge.
Is that everybody?
Okay, now I think we got one other case somewhere we need to go back to.
Dr. Anderson.
The Kittrell, did we do anything, ended up doing about that?
We need to have a hearing on her, Judge, and Dr. Anderson's traveling, so if we can do his by telephone, but it's all right with the defense.
That's not.
Well, if you find out when they're going on, we'll get your secret house. I think we can start out here. That's all that should be able to. Stipulate the compensating.
Judge, I apologize, and in discussing this with the Commonwealth, and I've been able to see Ms. Cottrell a few times. The Commonwealth has agreed to try to negotiate and get a resolution in this case. In lieu of that accommodation, we're going to stipulate the competency and capacity, that way the doctor can be excused.
Is the doctor, is his testimony gonna be that she is competent?
That's correct.
Okay, and so now that we've been faced with that ultimate truth, they're gonna stipulate to the competency. Now, what are we gonna schedule out? Thank the doctor.
The 31st.
31st, Judge.
Okay, we'll have scheduled the negotiation day. Ms. Cottrell, the good news is the doctor thinks that you're competent. That, you know, so and nobody else there in the jail got their papers, you got your papers, you're competent. So they're gonna schedule you a negotiation day on the 31st. And what's all she charged with?
Fleeing,
Fleeing and evading, so maybe they can get it put behind you, they'll be over there. You're either gonna come down here or.
I'll have her sent over, brought down here, Judge.
Yeah, we'll have you brought down here to Burkesville on the 31st, 1 o'clock.
Yes, sir.
We do a negotiation, and then the next court date's 29th or before that, if they can reach an agreement, okay?
Yes, sir.
Very much. Adair, do we have anybody else up there in your facility that we had to talk to today?
Oh, that's it. Will anyone be here to speak to me before the 31st?
Yes, Josie, I'll be over to see you
Okay,
31st.
okay, cool.
Okay, thank you very much.
Thank you.
Y'all may be excused up there. Is there any other criminal matter to come before the court? Okay, well, let's go off the record then. Okay. Let's go back on the record, and where is the show cause, Doc? Over here. Diversion completion document, Mr. Stockton, are you kind of focus on diversion completion document? You have Timothy Wayne Alexander.
That case we'll dismiss that one diverted, Your Honor.
Okay, dismissed, diverted. Jamie Michelle Hurt.
That'll be dismissed, diverted.
Okay. Billy James Kennedy.
That'll be dismissed, diverted.
And April Osborne.
That case is the one we filed the motion to revoke on, that we've going to negotiate on, because we just got the new indictment.
Okay, that'll be good. Now, we had the show cause docket. Daniel Appleby.
He's been paying since,
So he's paid.
no, he's been paying since morning, but he does not have a police. He didn't make them all on table.
Well, issue an arrest warrant, he can, for him, and he can, pay $200 toward the payment. Tiffany Bell.
But she made a $10 payment last month, and she's not actually this month. She said you reported all these.
Drug court in Albany. But
Paid this morning on the phone, Jessica,
how much?
$20.
Okay, scheduled for next month then. Cecily Davis.
Pay $30 less more. She's not paying.
Okay, issue a warrant, she can purge herself by paying $155. Is that it?
Yep.
Okay. Child support docket will come on at 1 o'clock. We are in recess. The record. Got it out there. All rise to the grand jury, please. Who's the foreperson of the grand? Everybody be seated, please. Who's the foreperson of the grand jury? Stand, please, there. Mr. Foreman, have 9 or more of you agreed on each of the indictments you have there?
Yes.
Mr. Bailiff, you pick them up and hand them over here to me. Thank you. Okay, ladies and gentlemen of the grand jury, I have reviewed the documents that you've sent to me. If any of these individuals are incarcerated, we'll probably send a summons to them. If they're not, we'll issue warrants with bonds sufficient to assure their appearance or protect the public if necessary. Y'all are kidding the mind. So, I want to remind you that it's crucial that you keep what you've heard in there, testimony, witnesses, confidential. You're all sworn to do that. And it will protect the public and the officers that are involved with it and that sort of thing. Does everybody understand that? Okay, also, I would remind you that if anyone tries to approach you to talk to you about any case, you're to inform them that you're on the grand jury and can't talk to them about it. Your next schedule to come in here on August the 29th, unless there is riot or insurrection or something in the world we live in, you can't ever tell when you're going to have a good riot or insurrection that you might be called in for. But thank you for your service. You may be excused till August the 29th. Okay, all rise for the grand jury. Y'all can be let out this way, okay? Okay, let's do the 1 o'clock docket, please. The child support docket.
Have one matter on it, so. Don't get it on the last one.
Commonwealth versus Rising, Nicholas Rising, is that correct?
Yes, Judge, this is just an order for future review. We've established wage payments. We established wage payments, so he is paying and it's working well. Just asking that the court review this matter on the 19th of September.
Okay. Is that it?
That's all I have, Judge.
Thank you. Okay, it's 1:05 and we have a 1:15 docket, but I can kind of flip down through here to see if there are any of these cases that everyone's here. Beauty Williams versus Danny Strong and others. Is anybody, are all the parties here on that?
Ken Henderson, the movement, Your Honor.
Okay, well, we'll come back to it.
I see Mr. Cook's on, Your Honor. He's got the Brent Shipman case. We could call that.
Yes, sir.
Is it a Brenda Shootman case?
Yes.
Yes, sir.
24 CI 0006. Brenda Shootman versus the Housing Authority of Burkesville, is that correct?
That's correct, Your
Who do
Honor.
you represent?
I represent the plaintiff, Your Honor.
Yeah,
It's Mr. Cook's motion, and it is well founded. I owe him some discovery, and it's ready. It's just not been typed.
hadn't been typed. How's it ready?
Well, it's been answered. It's just not been put in final form. We're a little bit in the lurch.
Mr. Cook, how much, what's the amount of attorney fees that you want to collect in this?
I don't want to collect any attorney's fees, Judge. I just would like to get Mr. Cross to send me his answers, if that would be all right. If you give him 10 days, is that enough?
I appreciate that, Matt. Thank you.
10 days, submit an order down if you want to, okay, to us.
Your Honor, I think I did tender an order just for a fill in the blank. If you want me to fill it in for you and send it to.
See it, usually, a lot of people are doing electronic stuff, so they don't usually, some people don't send them in advance now, 10 days from today, okay?
Thank you, sir.
Okay, thank you.
Have a good afternoon. May I be excused?
Absolutely, thank you.
Yes, sir.
These other cases are defaults and things, so we'll wait to the appointed time here, 7 minutes from now. Yeah, let's go off the record.
Your Honor, Mr. Henry's on now on the Williams case.
Okay, we have Williams versus Strong, 18 CI 00016. It's a motion to set aside.
Good afternoon, Your Honor. That's my motion. Ken Henry for Tammy Sarmiento.
Okay, go ahead.
Well, Judge, I think we set it out pretty clearly in the pleading that she was never noticed of the summary motion. Her former counsel did not inform her of the motion. Strikingly, though, as I was looking at the pleadings today, Mr. Cross indicated in the motion for summary judgment that he had served Ms. Sarmiento But then in his response to my motion to set aside, he indicated that he only got her address after the judgment was entered and served her with a copy of the judgment. So I think and her affidavit, she clearly states that she was not aware of this pending motion. So we're just asking the court to set this aside and give us a period of time in which to reply or respond.
Your Honor, we did,
Speak up.
as I set forth in my response, which was filed yesterday, it said we served Tammy, but the certificate didn't. I don't believe we did. I know we served Dustin Warren. Here's the only question about this case. Okay, Dustin Warren said he told me twice. He says, I don't represent her. He never filed a motion to withdraw. He never furnished us with an address. We went ahead and proceeded with summary judgment. The court's got discretion as to what to do. We think that Ms. Sarmiento should pursue her previous attorney on this, but if the court feels like it's appropriate for it to be set aside, I think you've got discretion.
She was one of the people that received one of the checks, right?
$12,500. And she's the only one we think we could collect off of. We settled, of course, with the bank.
So this would be setting aside only as to her.
12,500 plus interest, yes. We're done with Bank of Salina. We got a agreeable settlement with them, which I'm not permitted to say what that amount was.
I'm not really interested.
But it was less than what.
I'm not interested. Well, you think she'd been properly served? Did you serve her? He says you haven't served her.
We didn't notice her on the motion for summary judgment.
I'm not talking about notice. It was she originally served.
In this case.
Dr. Henry, are you saying she was never before the court or that she just wasn't served with a copy of the motion for summary judgment? Which one?
No, I'm not saying that she was not served in the case. She was before the court, Your Honor, but not served with a copy of the
Set
motion.
aside the summary. You want to set aside the summary judgment as to her.
That is
Now,
correct.
is there liquidity in this estate where you can enough to set aside?
Could you repeat that, Your Honor?
Well, where's the $12,500? I mean, so
It's in Ms. Sarmiento's pocket, as far as I'm concerned, less what Dr. Henry got.
I'm asking, is there any other money to be distributed in this estate? In other words, there's not enough to hold to get that money segregated. You follow what I'm saying?
Yeah, Virginia's estate all went to Bewley. Okay, so there's not. No.
Your Honor, my understanding, that estate is closed.
Yes.
Well, I don't know about that.
That's why Krista Carter's the substituted plaintiff. Dr. Henry's correct.
Yeah, well, I'll go ahead and set aside the summary judgment as to Dr. Henry's client. If you'll submit an order down for that, y'all can law it out with her.
We'll just. Ken, I'm sorry. When we talked the other day, I had forgotten, and then it came back to me. I've been in your office. We've talked on more than one occasion, but it's been years ago. So
it has been a while. That's
yes.
true. Your Honor, I believe we submitted a proposed order with our motion.
Signed, the clerk just handed it to me. It's signed, okay?
Very good. Thank you, Your Honor.
That was 18 CI 0006. Okay, West Bend Mutual Insurance versus Fletcher. The Fletcher never appeared after the withdrawal of their other attorney. I see that. Well, he's not here today, and it looks like they served time. Mr. Cross, you still have any contact with Mr. Wilkerson?
Yes.
Well, he's got a case on the docket here today that he entered an appearance on, and he's not here.
What's, Your Honor, I've got his cell. What's
West Bend Mutual versus Fletcher.
I'll see if I can contact you.
We'll come back to that case. Green River Rentals versus United Petroleum Transport.
Good afternoon, Your Honor. This is James Larimore on behalf of Green River Rentals.
Judge, I've not been able to get in contact with my client. We sent him notice of this motion. I've went back and done a court check record. It looks like we had an order with leave to amend the complaint, but and looking at the records, it looks like my client was served with something on May the 16th, and I wasn't aware that there was a new summons, a new complaint issued other than where that order had been entered. So I would just ask if I could have time to respond to that.
You're not in contact with your clients, or?
I've been trying to get in touch with my client, and we mailed him a copy of the letter, but I've
Where
not
does
been
he
able to
live?
reach him by phone. I'm sorry.
Where does he live?
He lives on the other side of Waterview.
Here in Cumberland County?
Yes, here in Cumberland County. And he was here the last
Well,
court date back in May.
Yeah, well, since he was here, I'll give you 10 days.
Okay.
10 days to file a response. And I'll pass over the motion for default for now, but if it hasn't been filed and served appropriately, I'll enter default judgment within 10 days.
All right. Thank you, Judge.
Thank
Thank you, Your
y'all.
Honor.
Center versus Collins.
And Judge, I spoke to Mr. Bertram this morning. We're going to submit an agreed order on the issue where there's a makeup day for this Tuesday,
Okay.
the 30th.
I don't even know the details.
Okay.
You tell me you got to agree with that.
And then we would like to set a status review for the August the 29th, just to
Okay,
make sure.
just
So we'll put that in order.
Just go ahead and notice it then, okay?
All right, thank you.
Carver versus Carver.
No, it's gonna be about 10 minutes to fix them.
Who was that? Who?
Elder George is
Is that okay with you?
that's fine.
Okay.
You can see that.
John David Dishran. And others versus Ricky Spears.
Glad it's on the other side of that, Your Honor. I'm not sure if
Okay, well, he's not here yet for that one either, so, okay, so he wasn't the previous one. Emily Beth Webb versus Joey Randall Webb. Hey, you're wanting a default divorce, is that right?
Yes, Your Honor, we had filed a motion for default. There's been no response in pleading filed. And my client is, asking that a default judgment be granted.
What are you gonna do about property division? Is there any property to be divided? You got any personal property you want to divide? Anything you got claims to?
We do have property, personal effects.
Well, I'm asking if there's anything that you want to file a claim to. See, what happens in court, somebody files a suit against you and you don't answer it, they can get everything they ask for. You haven't answered in this case.
Your Honor, my lawyer was supposed to,
Who is your lawyer?
he was T. Pennington or whatever, but me and him had a conversation today, so he's left as my lawyer or whatever, so I'm without counsel.
And Judge, if I may, I'm listed as counsel on the schedule and the docket sheet. When we were here last, you had indicated you were going to enter a default divorce and leaving open the issue of property settlement. At this time, as Mr. Webb had stated, we have a difference of opinion, and I never filed an entry of appearance, but if I'm entered in this case before the court, I will file a motion to withdraw an attached order. I'll also note to Ms. White's motion, I was never, if I am attorney of record, I was never served with the default motion. It was the certificate of service states that it was mailed directly to Mr. Webb. So
I did, Your Honor,
So you need to speak up.
Your Honor, I did,
You did what?
I did notice him through e-filing as well as email. And I didn't know if he was he had told me before that he had lost contact with his client, so I sent a copy to Mr. Webb as well in the mail.
There are no children involved.
There's one child.
What are you gonna do about that?
Right now, my client's,
You may be excused, Mr. Pennington.
thank you, Your Honor.
my client has asked for sole custody. Right now, he's visiting the child. I think it's alternating Saturdays and Sundays for an 8-hour period supervised by his mother.
Well, with the presumptions that exist in these cases now, I'm not inclined with him never really had an attorney in the thing. You're gonna have to get after this man.
Yes, sir.
You've been.
I really thought that.
Well, I know, but just thinking somebody's on it and calling them up and harassing your lawyer like all my clients used to always do.
I do have proof where I sent him.
Well, I'm not doubting about that, okay, but,
Yes, sir.
okay, you already have the decree entered, right?
Yes, Your Honor.
Okay, now how much property is involved here, personal property?
There is a home and,
So they got real estate?
there is real estate which was titled in his name, but she paid,
Well, I don't want to try the case here.
okay, but she has an interest in the real estate.
Premarital properties, what you're saying, you had it when you married?
I had the property when we married, but it wasn't paid off. when we
Yeah,
married.
well, so there's a marital interest in the equity, as they say, in the thing, so. You need a lawyer. Now, I'm not gonna.
I will definitely try.
And here's the thing about it is, are you gonna have testimony where one child involved?
There's one child,
How old is the child?
6, he just
Okay,
turned
I
6.
mean, are you gonna have testimony? I don't want you to tell me what it is that he shouldn't, it can overturn the presumption is what you're saying?
Yes,
As
Your
far
Honor.
as time sharing? Okay, well, I'm gonna give you 10 days, get a lawyer, place and, make the entry of appearance and then that your lawyer and Ms. White will schedule with my staff lawyers so we can have some hearings on this thing, okay? Go ahead and try the thing. So it won't be tried in 10 days, but it will be quicker than you got now, okay? The decree was already entered without the
It
division,
was.
right?
It was, Your Honor.
Will you prepare an order?
I will.
Give them 10 days.
10
to
days.
File, get an attorney and file an answer.
I will.
Okay, thank you. Loan Care LLC versus Alan Walker.
Chris Polito for the plaintiff loan carrier, Your Honor.
Tell me what you got here.
Got a motion for judgment order of sale on a foreclosure.
Okay, well, I will enter the judgment. I've looked at that. I'm gonna hold off on the order of sale, okay?
Yes, sir.
Yeah, and it'll be forthcoming, but there's some structural changes that we gotta go through before I start order of sale, okay?
Okay, what do we need to do?
You don't need to do anything. I'll take a note. It has nothing to do with you, really. I'll go
Yes.
ahead and get it done as soon as I can, okay?
Thank you, Your Honor.
Garner versus Garner. Okay, what do we have going on here?
Your Honor, we have filed a motion
Bifurcated decree, right?
for bifurcated decrees, number one. And there's certain vehicles that my client is asking to be able to sell because there's substantial indebtedness that he's trying to pay along, probably about $6,500 a month in marital debt. And he's asking if we can set a final hearing or mediation in this case.
Well, is there a lot of personal property?
There is. There's property.
It's consumed by debt, so.
Well, I didn't ask that. You know, that'll be the proof, but there's quite a bit of personal property.
Yes, sir.
And there's a business that you claim has a value.
Yes, sir.
Okay, and is there retirement money or anything involved?
Don't know the answer to that.
You know, any 401ks involved?
I'm not aware of
Deferred
any.
comp? How many children?
No children.
No children. What's the length of the marriage?
2 years.
2 years.
We agree to the bifurcation, Judge. We do not agree to sell the property yet.
Well, here's the thing about it. If they've just got a marriage of 2 years, you know, I don't know what interest she can have in it very much, but it's not right to hold him up on trying to sell things and diminish his debt and hold him captive to the debt payments of something she might not have a great interest in. But she deserves protection to make sure who's buying it, if it's an arm length sale and that sort of thing. So what can you do to show us that it's a good arm length sale?
I haven't.
Who's he gonna sell it to? Don't.
I haven't, he doesn't have a potential buyer. He could either advertise it on Marketplace or there's another alternative. Eminence Eagle Auction has personal property that they post online. I know they've got a sale now that's ending like August 8th or something. Whichever way the court prefers, if he could do it
Well, Ms.
advertising.
Gibson, what would give you a level of comfort that these are being sold and the debt's being applied appropriately?
There's been no discovery yet, Judge. We do not know what his assets or what his debts are. The only thing that's been exchanged has been the preliminary documents. We need to do some discovery on that. However, he's only asking to sell two vehicles. He's listed many others that are encumbered. One of the vehicles he wants to sell was purchased for my client, and 2 vehicles were traded in for that vehicle, and she doesn't have a vehicle.
One she's personally using now?
That's the one she was to use, but she does not have any vehicle. She has no possession.
Why doesn't she have that one now?
Your Honor, each of these vehicles are, there's no
I guess you were
equity.
finished, weren't you?
Yes.
There's no equity in any of these vehicles. As evidenced
Why did
by,
he choose the one that she was driving to sell?
she has a vehicle that she had before she was married. It's a 15 Tahoe, I think, or GMC, an 03.
What's the other vehicle you sell?
It's a 2017 work truck that he's had to replace that has.
Have you all tried to mediate this thing at all?
We have not.
I would ask that we.
When could you get him complete discovery on this?
Well, we've provided him with the preliminary disclosure. He's not asked for any discovery at this
Well,
time.
I didn't ask you whether he's asked for it or not. I asked when can you get it?
I can get him a copy of the debts and,
Give him a complete list of assets and liabilities and have your client to sign it.
I will.
Notarize it, get it over there to him so you can depend on it. When you get that, have an opportunity to review it. If your client takes exception to that, then we can have a hearing. I'll hear it myself.
Yes, sir.
We'll expedite with it. Okay,
Yes, sir.
can you do that within 10 days?
I can.
Okay, thank y'all very much.
Your Honor, I have this
Can you submit
bifurcated.
an order?
Decree.
You have what?
I have the bifurcated.
Are you in favor of the bifurcated decree
Yes, sir.
also? I've got it here. I don't have the last page here.
Well, you should be there,
Now, what I would suggest, and it's just a suggestion, that while you've got both attorneys here in the parties, you might step in the room back there and see if he can make an offer to cash her out of this thing. Save a lot of people a lot of legal fees and that sort of thing. And, you know, I mean, I'm not suggesting you offer a copious amount, but a good settlement and certainty is a good thing, you know, so you don't have to worry about this or that. Can y'all do that for me? Yes. Thank you very much. Remember, it's just 2 years. It's 2 years. Will you ever get Mr. Wilkers?
Your Honor, Mr. Wilkerson reports that an agreed order continuing this matter was submitted to the court. And he's not got notice of entry, but that's what he said.
I say I was at the docket sheet. So it needed to be based.
Is there any attorney for plaintiff here? If not, we'll go ahead and continue to win. No.
He just said it was an agreed order to continue.
He needs to come up with a copy of the agreement
I'll
or
have to
sit
read it.
down here and we'll enter it, okay?
It's fine.
Carver versus Carver.
Your Honor, can I just make that a while? Can you take up Mr. Levitt and I've got to meet with Fraser at Swan Pond Bottom at
Well, I
2:30.
sure wouldn't want to keep people going for the Swan Pond Bottom.
Well,
Is it Dishring versus
Yeah.
Spears? Okay. I'll get to the last case then. Good day. What do you got here?
Good afternoon.
Your Honor, Mr. Levitt needs a trial date, and I think we could set one in the scheduling order.
Y'all complete, what kind of case is this?
Well, Mr. DeSharon says Ricky Spears cut his timber, and Ricky says, yes, I did, but he told me to. That's what it amounts to.
Okay, has all the discovery been finished in this case?
No, but I've got some outstanding stuff with Ted. We'll probably take the party's deposition.
Well, we're not gonna set it for a trial.
Well, when we were here last month, you said we'd go ahead and set it.
Well, I'm changing my
Okay,
mind now
that's
because
fine.
you haven't finished your discovery.
That's
Okay.
fine.
How much more discovery? I mean, if you tell me, do you have your surveys done? You have a timber cruiser that's gotta be here.
Timber cruise has been done. It's an odd case because of the survey. These are adjacent landowners. It's an estoppel type situation. But I know we need to take his client and he wants to take our client. Ted, how long we need to do that?
I don't know, but last time I was
Get
here,
behind the microphone. Move over behind it.
and last time I was here, Judge, just a few weeks ago, you gave them 10 days to answer requests for production documents.
Have you answered? Oh, you admit that though.
Your Honor, I've got them, but when I was here, we thought Ms. Fields had prepared all that and I can't find it on the computer. So I've had to meet with Mr. Spears only today to do that. And I've advised Mr. Levitt of that. So that's test, I know.
You signed an order to.
I understand.
Ted, don't beat on me. Don't beat up on me too much.
It's not you, it's your client.
No, it's not. It's.
I didn't sue you.
It's him.
I didn't sue you. I sued your client.
Your client was the one that did the cutting, right? And he says he cut
That's
it
correct.
Ricky cut-
on an oral direction.
That's what he said.
Yes, that's our
That's
position.
what he said. He took our timber and sold it, pocketed the money.
And
There's no question about that.
well, the question is, did your client all agree on the line with you, Ted? I mean, it's an interesting case.
We didn't give him the timber, Judge. That's what he's talking
I
about.
think what happened, Your Honor, after it was cut, or after.
Why do we even bother having trials when the lawyers can come in here and testify? It's
Oh, I
much-
agree.
It's much quicker to get to resolution, you know.
I'm
It depends on which one of the lawyers you can or cannot believe.
Mr. Levitt and I, we'll just do whatever you.
Judge,
direct
you've
us to
known
do.
him, you've known this gentleman a long time. And
I know you do.
you do.
Ted, you've been around a lot longer than I have. I was in knee pants.
Okay,
You started
let me
breaking.
ask you something.
Yes,
What can you do to resolve this thing to his client's satisfaction?
you mean,
I mean, you got a settlement you can offer him?
no, it's our position, Your Honor.
I
that-
didn't ask what your position was. I just asked if you would come off the position and offer him anything.
Oh, I
And your
have to talk-
answer is no.
I have to talk to Ricky.
But it's always good to talk to your client before you come to court to find out what they really want to do. Where is Rick?
Where is he?
Yeah, is
Well,
he here
here's-
today?
He was out front about 30 minutes ago.
Well, why don't you see if before Mr. Lavitt leaves the building here, that you can call your client and see if you've got some kind of offer that you can make Mr. Lavitt.
Your Honor, he was hauling a load of logs to the mill and he didn't have his hearing aids in, and I really doubt if he'll answer the phone, but I'll try.
Okay, how much discovery do you need? What do you need from him?
Give him 10 more days.
No, here's the thing. When can you set these depositions?
That's what 45 days, Ted? That's pretty quick.
No, we're not gonna go 45 days.
I wouldn't plan on taking any depositions.
I'm gonna take his client.
He wants to take my client.
Okay.
That's fine.
When can you do that? Sometime during the next 10, 15 days?
I've got my calendar.
Get you, pull your calendar out. Let's get the deposition taken.
I'm in favor of this.
You know, sometimes these oral permissions are worth the paper they're written on.
Depends on what the jury says, I hope.
If it gets to them.
Ted, what about Monday, August 12th?
Okay, that's okay. What time do you want to do that?
At 1 o'clock here, or
Well,
I'll accommodate you. I had to go all the way to Lebanon, but since I'm late on stuff, I don't care to accommodate you.
I could do it that morning.
Okay, I can do it that morning. What time?
I'd say, let's do it at 9 o'clock your time.
Want to do it in your office? That's fine. We'll do it in your office because I'm late on stuff.
9 o'clock, that'd be fast time.
Oh, you said 9 o'clock my time.
Listen, there's only one time and that's wherever you're at.
That's 9 o'clock, that's Eastern time.
Eastern time.
Well, 8 o'clock central, that's fine. Okay.
Okay, then our next rule day here is on the 29th. We'll either, y'all will have exchanged all the information, taken all the depositions and everything, and if you need me to sign an order to get somebody to mediate it, we can do that too, but on the 29th, we're gonna set a trial date,
Fine, Your Honor.
okay?
You want me down here on the 29th?
Well, you don't have to be, you can be here on Zoom if you want to. If you get somebody in your office, can set it up for you.
29th of July.
Next month, yeah. So this won't cost you any time as far as a trial, is what I'm telling you.
No.
See what I'm saying? Because I mean, I'll get you a trial. The way I get trials dates is I don't have all these other dates clogging them up, you know. Y'all finish all your depositions and your negotiations, and if you need a mediator, do that.
Thank you,
Okay?
Your Honor.
Okay, thank you. Now, is there one more case on the docket? Is that right? Carver versus Carver.
She's, I think she's still in Lexington. Yeah, she's real down there.
Okay, what do you have?
Good afternoon, Your Honor. Chris Davenport from Mississippi.
Yes.
We filed two motions. I'm happy to tell you one of them is now moot.
Okay.
When we were last here, I believe it was in June, the court wanted the parties to set their depositions. We set those for July the 18th, but in the meantime, Mr. Carver's previous counsel withdrew and he did not have counsel at that time. So I had filed a motion to require those be reset and he be given so many days to get counsel. In the meantime, he's hired Mr. George and Mr. Lanham, who I believe is present today. And we have in the meantime coordinated to have those set for September 5th. So that issue's moot. The other motion deals with a confidentiality provision that the court ordered back in January. Judge, just brief history. There are 4 separate orders in your file that compel discovery from Mr. Carver. One of those is an order dated January 30th. And when we had that hearing, the court commented that basically of your own volition, you commented it seemed to you that Mr. Carver was maybe delaying discovery and financial discovery in this matter because he was facing indictment in Clinton County on embezzlement charges, I believe. And your honor thought that he may be more forthcoming to comply with these discovery orders if the documentation was kept at my office and could not leave my office. Your honor's provision for that was found in paragraph 5 of your January 30 order. What has happened is, as I was getting ready for the July the 18th depositions, discussing these matters with my client, I became aware that Mr. Carver has successfully resolved that indictment in Clinton County.
True.
It's no longer. And so the relief I'm asking is basically that provision be lifted because it has made difficult my client and my preparation for what will be a substantial deposition of Mr. Carver. I don't want to, and I don't think I need to go into details, but there's great disparity between documents we have subpoenaed from third parties, documents that were produced, and statements made by Mr. Carver in his discovery, and the account statements have been produced by Mr. Carver. So it's a very tangled web that does not agree with itself. And so in preparation for those depositions, I would like the ability for my client to have access to those documents to review and discuss would be on her own time without the necessity of coming to Bowling Green and spending that time in my office. Mr. Lanham, I got a response from him this morning, basically suggesting that I'm being duplicitous with my request and my request is meant for some other purpose. I really don't know what inference he's making there.
Judge, my understanding of. Let me ask you a question.
Yes, sir.
What are the purpose, do you think?
My understanding of the original order from January 25th was that petitioner's counsel could share those documents with the petitioner. That the order was to prevent the disclosure of those documents or anything in discovery beyond
You have
that.
no problem with that, right?
I have no problem with sharing the documents with petitioner.
Just to clarify with counsel, the order specifically.
Okay, well, he says he's willing to let you share it with your counsel, but the confidentiality should extend to her also. She should not be disclosing that information to you.
Yes, Judge, that's the whole point.
Okay,
My
what
response
else
to the
you got?
motion is.
That's really it, Your Honor. To clarify for counsel, that order says that those
It doesn't
documents.
matter what it says.
Yes, sir.
You heard what he agreed to.
Okay.
Let's don't try to go back and relitigate something we've already got agreed to.
Understood.
Okay, so do you have anything else?
No, Your Honor.
Okay.
Just one thing. Did you talk to your client about that issue, the time sharing issue?
Yes,
Are we in agreement on that?
I think we are. We need to,
Okay, well, let's announce whatever agreement that you got.
Yeah, and with fairness to
I'll
counsel.
tell you my understanding of it if that's helpful.
Sure, that's
Sure.
fine.
The week of August 5th, normally the time sharing that happens on Tuesdays and Thursdays would not happen for Mr. Carver. John Ross would be with Ms. Carver and Mr. Carver would pick up John Ross early on Friday.
Still call the juvenile's name, right? Just
Yes.
say the
I apologize.
the youth.
The infant child, that as an offset, for losing that time, that would be picked up on the Friday.
Friday the second,
Friday the second.
the preceding Friday.
Okay,
What
well,
I
that was my
suggested.
misunderstanding. Yes, that's agreed to.
I'm glad we got that worked out.
That's why you agree to that?
Absolutely.
You agree to that also? Okay, is there anything else?
Judge, should I tender an order just granting my
Yeah,
motion?
Just e-file something.
I'll do it.
Okay, thank y'all very much.
Thank you, Judge. Have a good afternoon.
I don't think any of this stuff is egregious enough to get attorney's fees on, so I'll let it go.
I'm not even asking today.
But I'm just telling you.
Yeah.
Okay,
Thank
thank y'all
you
very
very
much.
Yep.
Is there anything else to come before the conference? If not,
Probably going back.
I don't know, you.
I didn't.
Probably gonna reach it right there. It sounds like they're working here. Will you look back there and knock on the door, and see if there's any, if they're gonna need to submit